Rename.
Good morning, madam.
Good morning, sir.
Very well.
Very good morning to one and all. Today's session will start with Professor Dr. Ajay Kumar as the chairperson. He will be chairing this session. And he is Professor of Law, Dean Academic Affairs and Law. And this morning's session of his will be chaired. A number of papers have come up to us, including some of which we have listed here. And for this session, the very first person who is going to be the speaker here is Neha Saxena. Professor Ajay is one of the excellent teachers that we have in Chanakya National Law University. He has authored a number of books and he is member of editorial board of various committees. Under him, the PhD students are doing their PhD. So he has guided a number of students and the research scholars under him. So I welcome you, Professor Dr. Ajay Kumar, to chair this technical session, the first technical session. The speaker, the name which I have got right now is Dr. Neha Saxena. She is Assistant Professor, School of Law, Presidency University, and her title of the paper is Law Relating to Surrogacy. So once again, I welcome you all. Now it's over to Dr. Vidya Lakshmina.
A very warm good morning, and I think our presenter, Dr. Neha, are you with us? Dr. Neha Saxena?
Yes, ma'am. Good morning, ma'am.
Please share your chair. Yes. Visible.
Ma'am, just a correction. It's not Dr. Neha Saxena, it's Neha Saxena. After few months, I will become Dr. Neha Saxena.
All the best.
It's Miss Neha. Thank you so much, ma'am. Thank you so much, ma'am.
Yes.
Okay. So good morning, everyone. And the topic which I'm going to present today is law relating to surrogacy. And in this, I have mainly concentrated over 3 countries, that is UK, USA, and India, with regard to what is the law relating to surrogacy in these countries. So to start with, first of all, I'm just telling with what is the definition of surrogacy given by the Supreme Court for the first time in India in the case of baby Manji Yamada. In this case, the court said that surrogacy is defined as a recognized method of reproduction whereby a woman agrees to become pregnant for the purpose of gestating and giving birth to a child she will not raise, but hand over to the contracting party. It is a method of assisted reproduction whereby a woman agrees to become pregnant for giving birth to a child for others to raise. So this means that a person, that is a woman who is stranger to the party, she agrees to become the mother of a child who is not hers, actually. So if we will see, this concept of surrogacy is not new in India, actually. So we had in previous, or you can say in our text also, we will find there are some instances where you can see that there has been surrogate mother. So as you can see it on the screen, I have mentioned Queen Sudeshna in Mahabharata, she has sent her maid to become her surrogate. Then again, if we remember that, yeah, Lord Vishnu, he transferred the embryo from Devaki's womb to of Roni, who was another wife of Vasudeva. So you can see that the instance of surrogacy is not new. Yeah, it has been there, but yeah, there is no law at present exactly on this point. So legality of surrogacy could be found under Article 16 of Universal Declaration of Human Rights 1948, which says that men and women of full age, without any limitation due to race, nationality, or religion, have right to marry and find a family. So this is the only provision in our international regulations you can see which not directly, but to a certain extent deals with the right of, or you can say the law relating to surrogacy. Because there is not a universal law on this point, so various countries and various states in the country itself have different law on this point. So let's take an example: France, Germany, Sweden, and Spain. They have voted against surrogacy, whereas the countries like UK, South Africa, and Argentina, they have accepted surrogacy. So there is no uniformity on this point. So before starting with the law, just I would like to explain there how many kinds of surrogacy. So surrogacy can be divided into two kinds. First, on the basis of genetics of the child, which can be divided into two, that is traditional surrogacy and gestational surrogacy. Second is on the basis of payment received, that is commercial and altruistic. These are the kinds of surrogacy. So what is traditional surrogacy? So in this case, what happened? The female is inseminated with the sperm of a male partner of the infertile couple, and then she keeps or bears the child for 9 months. In this case, the child is genetically related to the father. That is, at least one gene is having father, but yeah, that is the other gene is belonging to the mother, that is the surrogate mother. In case of gestational surrogacy, what happens? The egg and the sperms are fertilized, and then they are transplanted into the uterus of the surrogate mother, and then she bears the child for the 9 months. So in this case, the child have both the genetics of the mother and father. It's just the surrogate is keeping that child in her womb for the 9 months. The next comes commercial surrogacy. In that case, when there is an agreement to give compensation to the surrogate for bearing the child, that is commercial surrogacy. And in altruistic, there is no payment involved. This means when the surrogate is bearing the child but is not getting any money or monetary compensation for that, that is what is the altruistic surrogacy is. Now directly coming to the law relating to surrogacy in UK. So in UK, the main act which deals with the surrogacy is Surrogacy Arrangement Act 1985. This act is the product of a controversy which happened in UK. In 1985, one woman, that is Kim Cotton, that was caught accepting money from an American couple for becoming their surrogate. It was the second case which came up before the court with regard to the surrogacy. So then it was felt that there should be a law on this point so that there should not be exploitation of the women as well as the exploitation of the child. So the law was made in 1985, but this law did not take into consideration the welfare of the child. It was mainly concerned, or it was mainly concerned with the surrogates only. It was not made as on the point of the child. So this law was amended by Human Fertilization and Embryology Act 1990, which was passed. So this law was amended. In this law, in that act, there was a provision relating to parental order, which required that the legal parenthood of the child should be transferred through a document from the surrogate to the commissioning parents. But for this parental order, there were certain conditions required. That is, there were certain conditions which would be fulfilled, then only a person will be allowed to transfer the child from the surrogate to the commissioning parents. So first it was applicant must be married over 18 years, then domicile of UK, at least one of them have genetic link to the child. These are the few conditions, you can say, which was necessary to apply for the parental order. Then again in 2008, again the Human Fertilization and Amendment Act was passed because the Act of 1990 was not sufficient to deal with the matter related to surrogacy. So in 2008, again a new act was passed. In this new act, two things were included. One, that same-sex relationship people can also have a child, and two people who are the live-in partners, they can also have a child through surrogacy. So now, with regard to law on the point in UK, it's the Human Fertilization and Embryology Act 2008, which governs the law relating to the surrogacy. So you can see that in UK, they have codified to a certain extent the matter relating to surrogacy. Though there are some flaws in the act itself, but yeah, they have tried to at least have a compiled law on this point with regard to surrogacy. So now next coming to the law relating surrogacy in US. So in US, because there are different states and they have different laws on this point. Few states allow surrogacy, few states do not allow surrogacy. So New Jersey was the first state to deal with the matter relating to surrogacy. So in the case that is J baby M, the court allowed the surrogacy. No, the court said no, surrogacy is invalid because it is against the public policy. The contract relating to surrogacy is against the public policy. Yes, but if surrogate agrees to bear the child, but without payment, that will not be an offense. That will be a binding agreement between the parties. So in this case, if you will see, we can see that the court has said that commercial surrogacy is invalid. The court has not accepted commercial surrogacy. Same if we will see the law in UK, New York and all, they have said commercial surrogacy is void. Only one state in US we can see, that is the California state, which has a uniform, a strong point of law on this point. So they have developed that's what they have developed through case law. It's not that they have a particular law on this point. They have developed this matter through case law. So in the case of Johnson versus Calaver, the court has upheld the surrogacy contract, and court has said that yeah, the surrogacy is valid and the parties it is legal and enforceable. So just after looking into the matter, these state laws, that is in few it is invalid, in few it is valid, we can see that there is no uniform law in US with regard to this surrogacy agreement. Next, directly coming to India. India is called the surrogacy capital of the world because they has so many favorable conditions with regard to this. There are doctors, there are women to bear the child and all. So because of that, it has been tagged as a surrogacy capital of the world. But there is no law on this point in India, though there have been initiatives has been taken by the government on this point to frame laws so as to avoid the exploitation of surrogate mothers and abandonment of the child and all. But at present, we don't have any law on this point. So what happened in 2006 when the surrogacy or assisted ART, assisted reproductive techniques were going on illegally, then and many mothers, many surrogates died and child died because of this. So ICMR have formulated few guidelines to deal with this ART. So these guidelines, few of the points are like that, okay, DNA test of the parents is necessary to know that whether they are parents or not of that child. In case if they are not, then adoption will be allowed, otherwise it will not be allowed. Then they should not be that the parents will not be allowed to abandon the child just because he or she is not physically fit, and surrogacy will be allowed only if the person, that is the couples, are physically and medically are incapable of bearing the child. Then only these are the few guidelines which were given by the ICMR to regulate the matter relating to surrogacy. But the first case which brought this matter into light in India was the Baby Manji Yamada case. In this case, what happened? The two couples which had their child through surrogate were Japanese. So when the surrogate was having the child, at that time the dispute arose between the couples and they parted their ways. Now what happened? The wife disagreed. She didn't accepted the child, but father wanted, and he wanted to take that child from India. That is, he wanted to take the child to Japan. But because as per Indian law, surrogacy was no there and no law was there on that point, he was not allowed to take the child because it was assumed that because the child is born here, he or she is an Indian. He was not allowed to. So this case was brought before the court that he wanted right to take that child. So in this case, the court dealt with the matter relating to commercial surrogacy in detail, and court legalized commercial surrogacy with the condition that the government should have a proper legal framework on this point. The government should make a proper law in this point. There should not be any confusion on this point. Then again, in this case, same matter came before the Gujarat High Court in Janblas case. Again, in this case, the court dealt with the matter and they said, no, we should at least have a law on this point. So there is no confusion and it should avoid the exploitation of the surrogate, welfare of the child, and even the exploitation of the parents also. So in 2008, the government drafted a bill on this point, that is Assisted Reproductive Technique Bill, and laid down the certain provisions that what are the rights of the party, patients, donors, surrogates, children and all. But this bill could not be converted into the draft form. It could not be converted into the law. Again, an initiative was made to make a law on this point in 2019. A bill was drafted, that is Surrogacy Regulation Bill 2019. And few highlights of the bill are that it defines surrogacy, prohibited commercial surrogacy. It provided that the surrogacy should be done in a registered hospital. Then there should be a particular procedure should be followed. Rights of the people should be there. There should be sperm bank and all those things. They have provided. They have given a detailed format of a detailed procedure how the surrogacy technique should have been taken. But again, this law could not be converted into a bill cannot be converted into a law. So at present in India, we can see that there is no law on this point. It's just what is the contractual, it is governed. So as per the contract, whatever it is, so on that basis, they are going through. But as such, there is no special or specific law on this point. So again, I would like to suggest that because at this point, and as we can see, many couples who are not able due to their physical or medical health, they are not able to bear the child. This technique is very helpful for them. So there should be a uniform law on this point so that people can know, okay, this is how you should proceed. Even at international level also, there should be a law, uniform law to govern this technique, and also the various countries should also frame their laws so as to avoid the exploitation of women, exploitation of children, and exploitation of the women, of the parents also. With this, I would like to end my presentation. Thank you. Any question, anything?
Questions? Yes, thank you so much, Neha Saxena, for presenting such a good paper on law relating to surrogacy. And you have highlighted about what were the reasons which should be there for legalizing the surrogacy. So we are in the very first technical session of this 3-day international conference on human rights, legal and social perspectives during second wave of COVID. And the first paper has already been discussed. So we can move on to the second paper. And this second paper is from Dr. Binita Das. She is Assistant Professor, Department of Education, Suran Das College. Binita Das. Have you joined, ma'am? Impact of patriarchy on women.
Yes, ma'am. May I audible?
Yes, ma'am. I'm just reading the topic of yours, impact of patriarchy on women, empowerment in Northeast India.
Yeah, ma'am. I'm not sharing the paper actually by PowerPoint. Actually, I don't get the time schedule. That is why I'm going to read my paper thoroughly.
Ma'am, a sincere request, could you please switch on your camera? We are on live on YouTube, so it would be very nice if possible you could switch on your camera.
Yes, ma'am.
Could you please switch on your camera
Oh, okay.
if that is
Okay.
suitable?
Okay. I'm going to join.
Sure. Thank you.
Okay.
And a sincere request to all the presenters, the estimated time limit is 10 to 15 minutes. Please kindly adhere to the timelines because we have about a lot of papers to be done throughout. So we do not want to compromise on any of the scholars. It's your work and you've made it so nice. So my sincere request, please kindly adhere to your timelines.
Okay, ma'am.
Yes, Dr. Benita, please.
Okay, ma'am. I'm going to present my paper. Ma'am, the title of my paper is Impact of Patriarchy on Women Empowerment in Northeast India. And the keywords are gender discrimination, gender equality. In introduction, in the 21st century world, gender discrimination, gender stereotyping, gender equality, and gender equity have been considered as an issue of great concern in India. In India, these issues have also been discussed in various platforms, particularly in educational institutions, NGOs, women's study centers, research cells, etc. And yet they are not percolated to the family levels. In most of the families, the rule of patriarchy is still being practiced, even though the same people talk about gender equality and gender equity outside the seminars, universities, and any other meetings or workshops. The reason is because of the patriarchy system of the society, where men have always enjoyed the rights and preferences to do basically everything except household work. This is patriarchy, where everybody considers man superior to man. Women are always considered inferior to men, and as a result, women's socio-cultural position has been lowered down. They are deprived of having social, economic, political, and cultural freedom, which are basic necessities of leading a life in an orderly manner. The women are compelled to become the victims of the ordinary customs and traditions of the society. In this social setting of patriarchy, they have to face many problems in the names of customs, traditions, and superstitions. Various social norms have compelled them to sacrifice their basic human rights. Monu states the fundamental principle that all their life, women are to depend on the males of their families for the gratification of their every need. During her childhood, her father is expected to protect her. During her youth, her husband is expected to protect her. And during her old age, this responsibility is naturally shifted to her son. According to Monu, women are unfit to be left independent, with her dependence on various people all her life being high. It is one-sidedly generalized that her father, her husband, and her son supposed to shoulder her all responsibilities concerning her. And in this way, the role of the females in the household are disregarded. This one-sided and ordinary practice served as the basis of establishment of male dominance and supremacy. Empowerment is the process where a group of oppressed people takes legal control and actively tries to overcome obstacles. Empowerment especially refers to the collective action by the deprived and oppressed to overcome the obstacles of structural inequality, which was previously the cause of their disadvantaged position. It is a continuous and multidimensional process by which women are able to realize their potential and overcome the obstacles of discrimination. The parameters of empowerment are the development of the ability to think critically, build self-confidence, build up group cohesion, and foster decision-making, action, and ensuring effective participation in social sense. An empowered woman would be able to develop self-esteem, confidence, and in today's world, it is important to think of women and their rights since they have been deprived of their rights to centuries. Women need resources that will help them to make decisions for their own lives. Gender study now requires more sensitivity from both men and women, as it means reversing all the ills that patriarchy has written and conditioning that everyone has been subjected to, even in matrilineal societies. The notion that men are stronger, more intelligent, that they are the protector, breadwinners of the families, and that they have greater rights to higher education and other opportunities has actually kept the women subservient. Nowadays, parents have started to give their sons and daughters equal opportunities in education, but this concept has not percolated to all levels of the society. The less aware are still perpetuating patriarchal principles in the way they think and behave. The lawyers representing the rapists in the Nirbhaya cases are perfect example of medieval mindsets that still dominate large part of this country. This paper is an humble attempt to study the impact of patriarchy on women empowerment, and I have written here the provisions for women empowerment in India. In the Indian Constitution, there are various provisions. I'm not going to read the provisions, but the area of the study is the Northeast India, Assam, Manipur, Meghalaya, Mizoram, Nagaland, Tripura, Arunachal Pradesh, and Sikkim are the 8 states which comprises the northeastern region. This region has a multi-ethnic and heterogeneous cultural background. The study will uncover the whole Northeast from some special aspects. And data and methodology, the paper is an attempt based on secondary sources of data that study the impact of patriarchy of women empowerment in the Northeast region for 4 fundamental areas like economic participations, opportunities, education, political participations, and health have been taken as indicators. Economic participations and opportunities, I present one table here. Arunachal Pradesh, Assam, Manipur, Meghalaya, Mizoram, Nagaland, Sikkim, Tripura, where the gap, female and male gap is visible. And table 2, urban and rural, I divided the tables in 2 parts, urban and rural, according to the census report of India. And for education, I also present one table here, and in this table also, and Arunachal Pradesh, Assam, Manipur, Meghalaya, all are presented. The literacy gap here is visible according to the census report of India 2011. And political participation, gender inequality exists in Northeast India in terms of access of education, employment, and health, and political participation both in the level of state and nation. This here also I present one following one table: participation of women in Assam Legislative Assembly election from 1952 to 2011, where the gap is visible between male and female participants. And Lok Sabha election also, here I present one table where the percentage of women participation is very low than male. Female participation is very low. And findings of the study is According to the table 1, where work participation rate is presented gender-wise, it is observed that for all the northeastern states, there exists a substantial gender gap. Education is one of the important indicators of the study to determine the status of women, taking into account the literacy rate of male and female. Table number 2 shows that for all the northeastern states, the gender gap in literacy exists. Males are observed to be more literate than that of the female. Arunachal Pradesh had the highest gender gap in literacy rate. Another indicator for the study is political participation of women in the northeastern region, and table 3 shows that the number of participating female candidates and elected female members in the Assam Legislative Assembly is very negligible. The fourth indicator of the study is health. Health is one of the broad indicators of the study, which is when gender disparity is seen all over the world. And improved sex ratio always indicates a better status of women in the society, but table number 4 shows a vast gender gap in infant mortality rate, which indicates that the status of women in the health sector is also low. And there are some suggestions for the few suggestions to improve the structure. Equal property rights should be given to the female members in the families, access to equal employment opportunities for women, equal educational opportunities should be provided to every female child in the country. A revolutionary sense in the social and cultural values and behavioral patterns is necessary for foster in the process of gender equality. Awareness programs should be arranged in the urban as well as rural areas about gender inequality and its negative impact on society. The mass media should be skillfully used to raise awareness about gender equality. And in conclusion, male dominance within the domestic spheres is still very rampant, and women still do the greater share of household activities. The male children are being brought up with a hyper-masculine view of manhood. Therefore, gender education must be imparted to the male children to eradicate the patriarchal motive from their mindset. Again, the practical reason behind the preference of male children is dowry and the marriage system, where the girl has to leave her own parents' home. Because of this, parents never want to educate their children, girl children. They consider it a waste of money. This notion should be eradicated from the mindset of the common people. On the other hand, looking at the Khasi tribe, which follow a matriarchal and matrilineal form of society, we get to know that births of female children are as much celebrated as are the births of male children. Taking the development of the Khasi society as an example, gender equality in our everyday patriarchy society can be promoted. Thank you, ma'am.
Thank you so much, ma'am, Dr. Binita Das, for presenting the paper relating to the impact of patriarchy on women empowerment in Northeast India. The things which you have highlighted, it's about gender inequality that exists in each and every sphere of the political, social, economic life of human beings. So we now move, thank you so much for this presentation. Now we move on to the next presenter. And the next presenter is Shahina Ahluwalia. She is a research scholar, Chanakya National Law University. Effects of COVID-19 pandemic on gender and health. This is her paper title. So over to you, Shahina.
Thank you so much, ma'am, and thank you everyone for having me here today. My paper is titled Effects of COVID-19 Pandemic on Gender and Health. As my title suggests, my paper will focus on the impact of COVID-19, specifically on gender and health. We all know that COVID-19 has affected lives globally, whether it's livelihood, whether it is health, whether it is education. COVID-19 has impact on every sector possible. But my paper is going to talk about the gendered impact of COVID-19. When I say gendered impact, I would like to concentrate on the consequences of COVID-19, specifically on women's reproductive rights, and also how gender norms and gender expectations were reinforced in this pandemic and the lockdown brought by it. Unfortunately, my laptop today decided that it is not going to work. So I will also read through my paper and discuss my paper and adhere to the timeline provided. The pandemic and the lockdown has strengthened the gender hierarchy and social norms that influence the issue of over reproductive control and reproductive rights. As I said, I argue that COVID-19 has had gender impact in the sense that it has reinforced certain gender roles and gender expectations that influence women's experience of and outcome of reproductive health care. I advance that lack of reproductive rights means infringement of human rights, as human rights require states to protect and respect right to sexual and reproductive health. In this paper, I will also discuss the relationship between human rights and reproductive rights. Now, what is reproductive rights? Reproductive rights are based on the recognition that all couples and individuals are free to make choice to choose the number, the timing, the spacing between children, and to have information and means to do so without any force, without any coercion. And they also have the right to achieve the highest level of sexual reproductive health. They also include the right of everyone to make their own reproductive choices without discrimination, violence, or force. When we talk about human rights, what are human rights? Human rights are rights that we have only because we exist as human beings. These are inherent rights, ascribed rights. These rights are inherent to all of us, regardless of the sex, gender, age, nationality, race, language, or any other condition. The discourse of reproductive rights and human rights did not came at the start of the human rights discourse. Actually, it was pretty late in 1968 when the first time a human rights conference was held in Tehran. That's when spacing was discussed. Spacing between children, an issue, was discussed as a human rights issue. Later after the conference, many conventions, such as Convention on the Elimination of All Forms of Discrimination Against Women, International Covenant of Economic, Social, Cultural Rights, promised highest attainable standard of health even in reproductive rights. There were several regional instruments also that started to accommodate issue of reproductive rights in their own regional instruments and started to protect reproductive rights and started to protect women's rights, men's rights, and also rights of the queer community. For my paper, I'm only going to concentrate on the impact of COVID-19 on women's reproductive rights. As I have defined human rights and sexual rights, if you'll notice, there is a link, a deep link between human rights and sexual rights. Human rights are intersecting with sexual rights. There are many rights that are intersecting with right to privacy is a human right, right to education is a human right, right to attain the highest standard of health is a human right. And these are also part of reproductive rights. So when I say that reproductive rights are being infringed, I also mean that human rights are also being infringed. As reproductive rights gives control of the body, physical and sexual, to an individual without any kind of discrimination, coercion, or violence, it can be viewed as an essential tool of empowerment, protecting one's individual agency. It gives liberty to an individual to make choices for herself or himself without any force or discrimination. It affirms personal autonomy. Therefore, reproductive rights intersect with a wide range of rights related to civil, political, economic, social rights, including health, life, equality, non-discrimination, privacy, and information. The link between reproductive rights and human rights make reproductive rights a part of human rights. Denial of reproductive rights means infringement of human rights. Unfortunately, gender discrimination still exists in our society. and it finds place in gender norms and gender expectations, making it difficult to protect their reproductive rights, also making it difficult for women to protect their human rights. I'm going to now discuss reproductive rights in India. India has ratified various international conventions that claim to protect reproductive rights, that promise to protect reproductive rights. India, having ratified Human Rights Declaration 1948, instruments such as Convention on the Elimination of All Forms of Discrimination Against Women, International Covenant on Economic, Social, and Cultural Rights, is obligated to protect and fulfill and promote these rights without any discrimination. As human rights is intersecting with reproductive rights, India is obligated to hence protect reproductive rights. The National Population Policy 2000 upholds the right to voluntary and informed choice in matters related to compensation. Honorable courts in India have implied in their verdicts that a woman has absolute right about whether she wants to continue with the pregnancy or not. A landmark judgment was the Puttaswamy ruling, which clearly recognized the constitutional right of women to make decisions about reproduction as part of individual freedom stipulated in Article 21 of the Constitution of India. Even in a suo motu PIL, in the Bombay High Court, stated that since pregnancy affects the woman's physical and mental health and well-being, an unborn fetus cannot be put in a higher rank than the rights of a living woman. The Medical Termination Pregnancy Amendment Act, which got recently assented by the President in March 2021, seeks to expand the scope of reproductive rights. The Act permits abortion on the advice of one doctor up to 20 weeks and two physicians between 20 to 24 weeks for specific categories of women, giving more autonomy to women to decide whether she wants to continue with the pregnancy or not. In another case, Independent Thought versus Union of India, the Supreme Court declared that whether a child is married or not, her human rights are very much alive and kicking and need acknowledgement and acceptance. This is also a very important judgment when you think of protection of reproductive rights, irrespective of whether the girl has attained majority or is married or not. However, there have also been conflicting court judgments which infringe autonomy in reproductive rights. One such case was the Honorable Supreme Court stated that if a woman undergoes abortion or undergoes tubectomy without medical reason or without the consent or knowledge of the husband, such an act can be treated as cruelty to the spouse. The judgment simply defied the concept of personal autonomy and personal freedom to take decisions about one's reproductive choices. It negates the ability to make informed decisions and seek treatment without fear, coercion, or violence, the very main characteristics of reproductive rights. Moreover, when we think of COVID-19, there were many barriers which were reinforced in the protection of reproductive rights. These barriers can be understood in terms of gender norm, and are restricted to the private domain, and men are given charge of the public domain. Now imagine a global pandemic where everything is under lockdown. There is restricted mobility, there is no education per se, educational institutes are closed, lack of medical facilities. What happens to a vulnerable group such as women in such a society? I'm now going to explain the impact of COVID-19 pandemic on gender and reproductive health. Gender is a social construct, unlike sex, which is a biological construct. By social construct, I mean the meaning attached with gender, man, woman, queer. There's a social meaning attached to it, such as the gender norms and gender expectations, how to behave in a proper manner, what can be the acceptable behavior, how should a woman behave, what will be appropriate for the society. It sets certain standards that are expected from the society for women. Gender norms can be understood as social principles that regulate the conduct of girls, boys, women, and men in the society. What is considered proper? Now, COVID-19 pandemic has created a lot of pressure on the medical infrastructure. We all know that, even healthcare. When we think of reproductive rights and the pressure created by COVID-19, we also have to think of the women in labor, the newborns, emergency maternal and reproductive health services, which have been badly impacted. Lack of staff shortages, lack of infrastructure, lack of operation theaters, lack of ward space, cesarean operations, abortions, post-abortion healthcare has been delayed due to the COVID-19 pandemic. The COVID-19 lockdown reinforced different gender norms, which increased barriers to reproductive health. Firstly, women is expected to be living in the private domain, where men are expected to be in charge of the public. This pandemic has reinforced this idea, which has affected women's access to healthcare. Secondly, the gender norms which make man responsible for the household decision suppressed women's individual agency about her individual choices, especially when we talk about reproductive rights. Thirdly, lack of education and awareness, especially in COVID-19 pandemic when the schools were shut, has created a lot of pressure on girl students, which has actually resulted in burdening girl students with studies when they have lack of access, technological access, especially as girls are staying in the house, they are burdened with household chores too. I'm now going to elaborate on these 3 points and explain how COVID-19 pandemic has impacted reproductive health, restricted mobility. The gender norm that women are expected to stay at home and responsible for household chores has made it difficult for men to access healthcare. Gender stereotyping, along with restricted mobility, has made it difficult for women to access abortion care, difficult for women to access contraception. All these consequences, and because of restricted mobility, women are less able to move out independently, seek help, seek contraception. In the pandemic lockdown atmosphere, this all has been reinforced by the gender norm, leading to negative effects on women's reproductive rights and infringement of her human rights. Lack of access to decision making. Let's go back to 2011 when the High Court of Punjab and Haryana reiterated women's right to reproductive autonomy by dismissing a suit filed by a husband against a doctor who had performed an abortion without the husband's consent, saying that it is a woman's personal right to give birth to a child. No one may interfere with the wife's personal decision to continue or to abort the child. However, this was one of the few cases that reached the court. Women are stereotyped to take care of the household and are not taken as an important partner in decision making per se. In fact, in India, the decision of having children or raising children, spacing is also a matter of collective decision because of the socio-cultural factors. Family members are involved. It's not limited to husband and wife or wife. I can even say that. This stereotype was intensified in COVID-19 pandemic, especially because of lack of privacy. When the whole world was under a global lockdown and everybody was restricted in the house, there was lack of privacy, lack of access to information, lack of access to confidential counseling, as pregnant women who did not wish to carry the pregnancy to term were frequently unable to leave the house. Now I will talk about lack of education and awareness. In India, the general gender role for women is to rear and bear children. This has resulted in less efforts taken by parents to get their daughters educated. This is a fact that we all are aware of. Moreover, lack of education and awareness makes women vulnerable. This gender expectation was severely impacted by COVID-19. When COVID-19 hit the world, a lot of our schools and colleges, educational institutes were shut down. Until now, we have to use technology to access knowledge, to access information from teachers. Girls are more vulnerable than boys of being differentiated in terms of access to technology to take online classes. As they are at home, they are burdened by household chores, taking time away from their studies. Furthermore, increasing poverty, because COVID-19 has also impacted right to livelihood and livelihood of several families as seen. Lack of opportunities. makes girls more at risk for child marriage. Child marriage increases the risk of unwanted pregnancies, which are really unsafe. Lack of education and awareness is deeply related to making conscious decisions about reproduction and sexuality, including contraception, family planning, and abortion. Lack of access to services. About 112 instances of taking permission from honorable courts for termination of pregnancy surfaced after COVID-19 lockdown was imposed in March 2020 till September 2020. This is a huge number, but why did this happen? Because access to vital reproductive health treatments were brutally hampered in this pandemic. The lockdown had unprecedented impact on women's ability to access safe abortion care. In such a situation, they were left pregnant with few choices, either to continue the pregnancy whether they wanted it or not, or attempting an unsafe abortion, or waiting until the relaxation of lockdown restrictions to probably undergo a second trimester abortion in a health facility. This was declared by the center. The public health sector was also impacted, as the public health sector has limited the long-term production of contraceptives as a result of COVID-19 pandemic. According to the center's advice, the public health system has discontinued providing sterilization and IUCDs. This is also limiting choice and access to reproductive health care, which again breaches women's human rights. To conclude, I would like to say these rights that COVID-19 pandemic has influenced and impacted are not only limited to reproductive rights. We should look at them as human rights because it involves so many more intersecting rights, such as right to privacy, right to information, right to education, right to protection against child marriage, especially in a society like India, where women are still not treated at par with men. The pandemic and lockdown has reinforced several gender norms that breach human rights. Restricted mobility, lack of access to services, lack of awareness and education, lack of access to decision-making forced women to bear the brunt of the gendered impact of COVID-19. Honorable courts in India have protected reproductive rights in many cases, as discussed, and India is also a party to international covenants. However, when this pandemic occurred, it seemed that India failed to predict the gendered impact that COVID-19 would have. It did not change laws relating to abortion, which could relieve women from unwanted pregnancies in a global emergency like this, where many facilities were shut down. Nor did it deal with contraception in a correct manner, which would avoid so many unwanted pregnancies. Now, with the Medical Termination Amendment Act 2021, women's abortion may become safer, but there is still a long way to go. Indian judiciary and Indian society need to recognize women's individual agency and her choices. Moreover, there is a need to reiterate the protection of reproductive rights. That protection of reproductive rights means protection of human rights, something that is inherent with us and something that cannot be taken from us. Thank you so much, everyone.
Thank you, Shahina, for illustrating such a good paper about women and health, the reproductive rights of women. You raised certain issues which are quite pertinent for these specific when we are facing through this pandemic situation. So once again, I congratulate you for presenting such a good paper. Now, the next presenter for today's session is Pallavi Devi. She is from Assam, PG Department of Law, Guwahati University, Guwahati, Assam. And the title of her paper, is she there, ma'am?
No, ma'am. Because of some reason, she is not able to join today.
No. Pallavi is there, Meru. She has joined. She will be presenting paper. Pallavi is there very much. Can't you see her? Pallavi, are you there?
Yes, ma'am. Okay, I will join. Okay, welcome, ma'am. So sorry.
So her title of the paper is The Law on Adultery, from Yusuf Abdul Aziz to Joseph Shrine in Recognition of Women's Sexuality. Over to you, ma'am.
Yes, ma'am.
my screen visible, ma'am?
Yes,
Yes, ma'am.
yes, very much.
Screen is visible.
Yeah.
Yes, ma'am.
Okay. So I had only prepared my slide, but I was not prepared today to present. But anyway, respected chairperson and co-participants, the title of my paper is The Law on Adultery from Yusuf Abdul Aziz to Joseph Shrine. So in the very first slide, I would like to take you to a journey that the Supreme Court has made in 1950. Joseph Shrine decided in the year 2019. And in Yusuf Abdul Aziz, the interpretation was such that Article 15, Clause 3 of the Indian Constitution was interpreted to be as a protective shield to the women. But while making the journey from Yusuf Abdul from 1954 to Joseph Shrine, the interpretation has changed, and thereby the judgment that was, the decision that was given in Yusuf was declared unconstitutional in Joseph Shrine. And in Joseph Shrine, the agency of women's sexuality has been recognized. Therefore, it has been more than 60 years, from 1954 to 2017. There are almost more than 6 decades to recognize the agency of women's sexuality, that women have choices, and even in the wedlock, even after they get married, they have they are not supposed to be men's property. And this, while Joseph Shrine has helped in recognition of women's sexuality, this has laid the foundation for recognition of marital rape. So to begin with, so if we look carefully at the wordings of section 497 of Indian Penal Code, we will see the definition as whoever has sexual intercourse with a person who is and whom he knows, or has sexual intercourse with a person who is and whom he knows or has to believe to be the wife of another man, without the consent or connivance of that man. That means that without the consent or connivance of the husband, such sexual relation, not amounting to the offense of rape, is guilty of the offense of adultery. And therefore, the offense of adultery should be punished with either description, with imprisonment of either description for a term which may extend to 5 years, or with fine, or with both. In this kind of cases, the wife shall not be punishable as better. So this was the definition under section 497 IPC. Therefore, what is implicit in section 497 IPC is that the Indian women's sexual autonomy, her choice, her wish to have sex outside the wedlock is not recognized by law. So this is also one of the reasons why non-consensual sexual relation by a man upon his wife when she is above 15 years is not a criminal offense. This is the very reason, because of section 497, non-consensual sexual relation upon a man by his wife who is above 15 years is not recognized as a criminal offense. And therefore, therefore marital, to bring reforms in marital rape, the provision is very stubborn. Therefore, the safeguards provided in section 497 IPC only regards women as a men's property. But if we look to section article 13(1) of the Indian Constitution, it says that the pre-constitutional laws, to the extent of inconsistencies with the fundamental right, is void. And under Article 13, Clause 2 of the Constitution, that state shall make no law abridging the fundamental right. Therefore, by dint of Article 13, Clause 1, any inconsistencies with the fundamental right is void. And here in this particular section, men and women, they are treated differently. One have a choice to his own autonomy, and one does not, because she is married, she loses her autonomy or her sexual agencies. Now therefore, this section 497 has the element of Victorian morality, which could only be justified by a colonial court, not by a democratic court under the Indian Constitution. Now, if we see the line of reasoning in Yusuf Abdul Aziz, this was a case which was judged by the Bombay High Court. Here, the legendary judge, Justice Vivian Bose, relied on Article 15, Clause 3 of the Constitution, which allowed the state. Now, the word state has state is very powerful, because the word state also includes the instrumentalities of state. Vivian Bose relied on Article 15.3, which allowed the state to make a special provision for women, and held that such an exclusion from punishment for women folk was considered as a protective legislation in favor of women. And therefore, Section 497 did not violate any equality provision guaranteed under Article 14. Now, this was the line of reasoning in Yusuf Abdul Aziz. Now, if we see to the equality concept that has been provided under the Constitution of India, now the equality clauses are there in Article 14 to Article 18. Now, over a period of time, the concept of fundamental right has been shifting in the individual rather than a group. Now, when we talk of group, we mean collective rights. And when we talk of fundamental rights, we understand the concept of individual rights. And we have seen that in the recent years, in the last 3-4 decades, that in matters of non-economic matters, like in the area of freedom of speech or in the area of right to life, the line has been shifting towards the individual. Whereas in matters which is not related to economics, the line has been shifting in favor of social control. And because of this judicial creativity and also a changed time, we have rights like the right to privacy, the rights of LGBTQ to live life with dignity, equality, and so on and so forth. Now, if we see the saga of adultery law, that was the first, Yusuf Abdul Aziz was the first case that has come up to the court. That was in 1954. But there are another 2 cases. Those cases are Soumitra Vishnu that had came up in 1985, and another was Revati versus Union of India that had came up in 1988. Now, we had already seen the line of reasoning in Yusuf Abdul. But in 1985, in this case, it is said that women did not need to be included in the law as a party which can make complaint, because in the law of adultery, under Section 497, women are not only, if we see the definition, it has already been laid there that the wife shall not be punishable as an abettor, though she has made love outside of wedlock. But the other wife with whom, who is also a sufferer because her husband has made an extramarital affairs outside her relationship, outside that wedlock, because the law is such that wife shall not be punishable as an abettor, one wife cannot sue another wife. So this was the provision. So in 1985, let me go to slide 6. Okay, so in 1985, the judgment was also followed Yusuf Abdul Aziz reasoning, and same was the case in 1988.
Sorry to interrupt you. Please try to be more concise because we have less time. It's a beautiful paper, but we have less time right now.
Okay, ma'am. Okay. So the reasoning was same till 1988. But if we look at the if we do a perusal of adultery law, we will see that that it is neither gender sensitive nor a gender neutral one, because the law for the this is because the laws for the it is the men which is only punished in case of adultery, and no action is suggested for women. Now, first, because that only a husband is aggrieved by an offense of adultery, by implication, the wife who has an adulterous husband, that wife is not considered as an aggrieved person. Now, because of lack of time, I will just go to the case of Joseph Shrine, what Chief Justice, then Chief Justice Deepak Mishra, along with Justice Khanwilkar, along with Justice Nariman and Indu Malhotra, they have elaborately discussed Article 15.3, and they have come to a consensus that Article 15 Clause 3, the situation now demands a different interpretation. So they all held together that Article Section 497 IPC violates the Equality Clause. Now, adultery, they have, in this case, honorable judges have given their understanding that adultery should only be considered as a matrimonial offense, and it should not be considered as a criminal offense. And the remedy for a matrimonial offense may be sought in divorce or separation. And they have come to a conclusion that if there is any marital demeanor, or if somebody is not loyal to marriage, or if they feel cheated, they can take recourse to the remedies that are available. But to say that an institution of marriage will not be destroyed if the men have sexual relation with a single woman, or to say that it will not amount to adultery if she indulges with other person with the consent or connivance of her husband, it is not only archaic, but it has also dishonest intention, and it moves away from today's criminal jurisprudence, where the philosophy is not to treat women as a belonging or the property of a husband. It is just a provision, Section 497 IPC is just a provision to beat his wife. So this case has laid the foundation to recognize marital rape as a where there must have some reforms, and the court can look into Navtej Singh Johhar's line of reasoning for recognition of sexual autonomy and consent, and to rely on it. Therefore, Joseph Shrine have firmly established the foundation for recognition of marital rape as an offense. Thank you, ma'am.
Thank you so much, ma'am, for presenting the paper on adultery and highlighting the IPC, that is the Indian Penal Code, and also about the fundamental rights which is to be discussed, the various articles that has finally given shape to this whole situation, and how it has to be improved for the better future. So I now come to another speaker, Dr. Jyoti. She's a postdoctoral fellow, ICSSR, New Delhi.
When?
Is Dr. Jyoti there?
Yes, ma'am, I'm here.
No, ma'am.
Yes, ma'am. Am I audible, ma'am?
Check, ma'am.
Hello?
You are audible. Just let me announce the title.
Yes, ma'am. मैम, आज मैं जो प्रेजेंट करने जा रही हूँ, बिहार की प्रवासी महिलाओं के शैक्षणिक अधिकारों का जो शोषण है, उसको लेकर मैं एक लेख प्रस्तुत करने जा रही हूँ, जो कि दिल्ली के स्पेशल रेफरेंस में रिलेटेड है।
मैडम, आपके पास 10 मिनट का समय है, कृपया उसका ध्यान रखें। आप शुरू कर सकती हैं।
यस मैम। मैम, बिहार से कुछ महिलाएं हैं जो कि दिल्ली में आकर माइग्रेटेड लाइफ को स्पेंड कर रही हैं। उनके जो एजुकेशनल राइट्स हैं उनको लेकर मैं आज बात करूंगी। तो जैसे कि हम सब जानते हैं कि जो एजुकेशन है वो हमारे राइट्स को हम किस तरह से समझ सकते हैं, उसकी पावर हमें वो प्रेजेंट करती है। लेकिन कंडीशन क्या है आज के समय में कि जो माइग्रेटेड विमेन हैं जो कि बिहार से दिल्ली में आ रही हैं, उनका जो एजुकेशन लेवल है वो बहुत ही लो है, बहुत ही ज्यादा कम है। ये जो आर्टिकल है यहाँ पर मैं दिल्ली के 3 रिसर्च एरिया को मैंने लिया है, जिनका नाम है मैदानगढ़ी, शहादरा और पंजाबी बाग। और यहाँ पर बहुत ही हैरानी की बात है कि जो माइग्रेटेड विमेन बिहार की दिल्ली में है, 55% के लगभग महिलाएं ना तो पढ़ सकती है ना ही लिख सकती है। ये जो डाटा है ये प्राइमरी सोर्स से लिया गया है, फील्ड वर्क से ये डाटा निकल कर सामने आया है। तो 3 एरिया मैंने लिए हैं, जैसे कि मैंने आपको बताया था अभी। और जो रिसर्च टेक्निक है उसके रूप में 200 रिस्पोंडेंट से मैंने सर्वे किया था और डाटा कलेक्ट किया था, इंटरव्यू लिया था क्वेश्चनियर के माध्यम से, और सेकेंडरी सोर्सेज का भी इसमें इस्तेमाल किया गया है। इसको मैं एक सारणी के द्वारा भी प्रेजेंट करना चाहूंगी कि जो क्लासेस हैं, जो कक्षाएं हैं, उनको डिवाइड किया गया है। जैसे प्राइमरी लेवल की कक्षाएं हैं, फिर 7 to 11 है, BA है, या फिर अनएजुकेटेड विमेन है। इनका जो डाटा है ये सारणी पूरी तरह से प्रेजेंट कर रही है। कक्षा 1 से लेकर 6 तक मैदानगढ़ी में सिर्फ 16.25% महिलाएं हैं जो कि एजुकेटेड हैं और जिन्होंने कक्षा 1 से 6 तक की एजुकेशन ली है। शहादरा में 35% है, पंजाबी बाग में 17.05% है। क्लास 7 to 12 अगर हम बात करें तो मैदानगढ़ी में ओनली 13.75% है, शहादरा में 20 और पंजाबी बाग में 26.25% है। ग्रेजुएशन लेवल की बात करें तो तीनों एरिया में सिर्फ मैदानगढ़ी में 1 विमेन और पंजाबी बाग में 1 विमेन है जो कि BA जिसने की हुई है। शहादरा में ये परसेंटेज बिल्कुल 0 है। और अगर हम अनएजुकेटेड विमेन की बात करें तो मैदानगढ़ी में सबसे ज्यादा विमेन हैं जो कि अनएजुकेटेड हैं, 68.75%, शहादरा में 45% और पंजाबी बाग में 55%। इन तीनों एरियाज को इसीलिए सिलेक्ट किया गया है क्योंकि यहाँ पर बिहार से आने वाली महिलाएं बहुत ज्यादा संख्या में निवास कर रही हैं। तो सारणी के बेस पर ये आंकड़े निकलकर सामने आए हैं, जैसे कि मैंने अभी आपको क्लियर भी किया है। और अगर हम बात करें टोटल कैंडिडेट्स की, टोटल रिस्पोंडेंट्स की, तो 200 उत्तरदाता बनते हैं। 200 महिलाओं से क्वेश्चंस पूछे गए हैं, जिसमें अगर हम बात करें तो कक्षा 1 से 6 तक सिर्फ 20.5% महिलाएं हैं जिन्होंने प्राइमरी लेवल की एजुकेशन ली है। क्लास 7 से लेके 12 तक सिर्फ 20% है। BA सिर्फ 2 महिलाएं हैं जिसका परसेंटेज सिर्फ 1 बनता है। अनएजुकेटेड विमेन सबसे ज्यादा है, 58.5%। ये वो अनएजुकेटेड वुमेन है जिनको ना पढ़ना आता है ना लिखना आता है। बात करते हैं कि जो महिलाएं हैं उनका जो एजुकेशन लेवल है वो इतना लो है, इसका रीजन क्या है। तो जब उनसे बात की गई और जो रीजन निकल कर सामने आए वो बहुत सारे रीजन थे। सबसे पहले ये था कि उनकी जो फैमिली कंडीशन है वो ठीक नहीं थी। फैमिली में कई बार जो पेरेंट्स होते हैं वो एजुकेटेड नहीं होते, तो वो अपने बच्चों को गाइड नहीं कर पाते हैं कि आपको किस तरह से एजुकेशन लेनी है, कितनी एजुकेशन लेनी है। इसके अलावा बचपन से ही महिलाओं पर फैमिली की रिस्पॉन्सिबिलिटीज डाल दी जाती थी। और जो लड़के और लड़कियों की एजुकेशन को लेकर अगर बात की जाए तो लड़कों की एजुकेशन को ज्यादा प्रेफरेंस दी जाती थी क्योंकि उनका बचपन बिहार में बीता था। तो उन्होंने अपने जो एक्सपीरियंसेस बताए थे उसके बेस पर ये कारण निकलकर सामने आए हैं। इसके अलावा जो महिलाएं होती हैं उनके ऊपर रिस्पॉन्सिबिलिटी होती है कि उनके जो छोटे भाई बहन होते हैं उन्हें संभालना होता है। माता पिता के साथ खेतों में जाकर उनको मजदूरी करनी पड़ती है। इसके अलावा लोगों की मानसिकता कि विमेन को ज्यादा एजुकेशन नहीं देनी चाहिए, ये भी उनके एजुकेशनल राइट्स का एक्सप्लॉइट करने का एक इंस्ट्रूमेंट साबित हुआ है। इसके अलावा एक और मेन रीजन जो निकल कर आया है कि जो प्राइमरी लेवल पर जो स्कूल होते हैं वो उनके घर से काफी दूर थे। प्राइमरी लेवल के बाद उनको अगर एजुकेशन लेनी होती थी तो उनको गांव से बहुत दूर जाना पड़ता था, घर से बहुत दूर जाना पड़ता था और वो माता पिता उनको नहीं भेजते थे। तो ये भी एक मेन रीजन रहा है उनके एजुकेशनल राइट्स के एक्सप्लॉइटेशन का।
Can you just jump over to conclusion because
Yes,
we have paucity of time.
Yes, ma'am. Definitely, ma'am. लेकिन मैम ऐसा नहीं है कि जो महिलाएं हैं उनकी मानसिकता नहीं बदल रही है एजुकेशन को लेके। उनकी मानसिकता में बदलाव आ रहा है क्योंकि वो दिल्ली में रह रही हैं, यहाँ आकर उनको देख रही हैं कि एजुकेशन की कितनी इंपॉर्टेंस है। तो वो अपने बच्चों को एजुकेशन देना चाहती हैं, अपने बच्चों को एजुकेट करना चाहती हैं और लड़कों को एजुकेट करें या फिर लड़कियों को एजुकेट करें इस बारे में वो कोई भी भेदभाव नहीं बरतती हैं। दोनों की एजुकेशन पर वो फोकस कर रही हैं। इससे ये क्लियर होता है कि उनकी जो मानसिकता है एजुकेशन को लेके वो चेंज हो रही है मेट्रो सिटी दिल्ली में आकर रहने की वजह से। इसके अलावा महिलाओं का कहना है कि अगर वो एजुकेटेड होती तो उनका जो एम्प्लॉयमेंट है, उनका जो रिस्पेक्ट है या फिर उनकी जो पार्टिसिपेशन है वो बहुत ज्यादा हो जाती, कुछ ना कुछ वो काम जरूर कर सकती थी। आज वो यहाँ पर आकर रहती हैं, इतना अच्छा काम नहीं कर पाती है, छोटा मोटा काम वो कर पाती है जिसको करने के बदले में उनकी जो इनकम है वो बहुत ही नाम मात्र की होती है। तो उनका ये कहना था कि अगर वो एजुकेटेड होती अच्छी तो कुछ ना कुछ जॉब वो दिल्ली में आकर कर सकती थी और इकोनॉमिक कंडीशन को इम्प्रूव कर सकती थी। तो रोजगार, सम्मान और निर्णय लेने की जो भागीदारी है उस पर उसको हम एक सारणी के द्वारा भी प्रेजेंट कर सकते हैं, जिसमें महिलाओं का कहना है कि अगर वो एजुकेटेड होती तो उनको रोजगार मिलता। सारणी में सामने है कि जो मैदान गढ़ी है यहाँ पे 56.25% महिलाओं का कहना है कि उनको रोजगार मिलता, शहादरा में 62.05, पंजाबी बाग में 47.05 है। इसके अलावा उनकी रिस्पेक्ट होती, क्योंकि कई बार ऐसा भी आया है कि प्रवासी होने की वजह से उनको इतना सम्मान नहीं दिया गया है, उनको अछूतों की तरह उनके साथ व्यवहार किया जाता रहा है। तो ऐसा भी नहीं होता अगर वो ज्यादा एजुकेटेड होती तो। इसके अलावा उनका ये भी कहना था कि अगर वो एजुकेटेड होती तो अपने निर्णय को, अपने डिसीजन को खुद अपने दम पर ले सकती थी। साथ ही कुछ महिलाओं का कहना था कि वो इस बारे में कुछ भी रिप्लाई नहीं करना चाहती हैं। तो यहाँ पर मैं यही कहना चाहूंगी कि जो लड़कों और लड़कियों की एजुकेशन है उसके बारे में इनके बीच में कोई भेदभाव आज के समय में नहीं रहा है। एजुकेशन को लेके उनकी रुचि बढ़ रही है, अपने बच्चों को वो एजुकेट करना चाहती हैं। और लेकिन फिर भी अगर हम उनके खुद के एजुकेशनल राइट्स की बात करें तो उनकी कंडीशन बहुत ही ज्यादा कम है। आज वो स्ट्रगल कर रही है, चाहे वो एजुकेशन को लेकर हो, चाहे वो इकोनॉमिक कंडीशन को लेकर हो या फिर सोशल कंडीशन को लेकर हो। हर लेवल पर माइग्रेटेड विमेन को दिल्ली में आकर स्ट्रगल करना पड़ रहा है। और महिलाओं के पॉलिटिकल राइट्स के लेके हम बात करते हैं, लड़ाइयां लड़ते हैं, लेकिन दूसरी ओर आज भी समाज की मानसिकता ऐसी है कि उनको एजुकेशन देने से वंचित रख दिया जाता है। तो जरूरत इस बात की है कि ये जो इनइक्वालिटी है इसको दूर किया जाए और उनको ज्यादा से ज्यादा अवेयर किया जाए। थैंक यू सो मच मैम।
धन्यवाद डॉक्टर ज्योति, आपने बहुत अच्छी तरह से दर्शाया। आपने 3 जगहों को लिया है दिल्ली के, और उसमें 55% प्रवासी महिलाओं की समस्याओं को आपने बखूबी इस शोध कार्य में आपने दर्शाया है। आपका बहुत बहुत धन्यवाद। अब now I'm moving on to the next participant, Sarah Wilson and Anjana Shainuddin, student of Azhar Law College, Kerala. Are they present? Sarah Wilson.
Yes, ma'am. Ma'am, can you please add Anjana Shainuddin as also a panelist member, as she is also presenting the paper? Anjana Shainuddin, my co-author.
Okay.
We have paucity of time. If both of you can just give introduction and then come over to your, finding, that will be very nice, because we have to start our another session. So please bear with us. Thank you.
The topic of there is why minority rights are important. So please share it quickly. And as suggested by Professor Mishra, due to paucity of times, you have to limit yourself. Sarah, I hope I am audible to you. Sarah Wilson. Anjana Shainuddin.
Ma'am, Anjana Shainuddin is presenting the paper. Please add her as the panelist member.
Okay. So the technical team, please check whether Anjana Shainuddin is now a panelist. Promote her to the panelist.
Yes, because we have put, it's a combined paper. So wherever it is a combined paper, we have put both, their name. Like,
Miss Anjana, I have allowed you. Now she can join. She is here. I think so. Miss Anjana, are you there?
Neeru Prabha ma'am, actually
Yes.
Anjana Sainuddin will be presenting. Sanjana Sarah Wilson is the other name.
Okay. So Sarah Wilson is already in the panelist, no? She is already in
She
panelist.
wants Anjana Sainuddin. Okay.
Yes, I have allowed her. Yeah, okay.
Okay, Anjana, just start. Give a small introduction and then come to the facts of it and then conclude as soon as possible. Anjana, will you unmute yourself? Unmute yourself.
Unmute.
Unmute
Hello.
yourself.
Hello, ma'am.
Yes.
Audible, ma'am? I'm audible, ma'am?
Very much.
Introduce the paper and then come to the conclusion as soon as possible, please.
Okay, ma'am. And fellow member, Anjana Sainuddin, and so our topic and that today India is one of the most powerful developing nation, and minority issue has become an important fact and an important discussion principle of free democratic society. So these rights are not privileges, but to ensure equal respect for members of different communities and to bring all members of society to a minimum means to observe the freedom of individual as one of the core value of democracy. So, are minority rights sufficiently protected? So this is the major question in this era. So the continuous violence and crimes against the minorities like Muslims, Sikhs and Christians have been popping up on daily in India. So the Indian constitution does not define minority, but it's defined minority based on religion and languages. Their rights that have been laid down in part 3 of Indian constitutions are legally enforceable, and the rights which have been laid down in part 4 of the constitution are not legally enforceable by law. And my co-author will say the conclusion. Thank you, everyone.
Thank you so much. Now, Sarah, you start with it.
Good morning. At last, I would like to conclude that protecting human rights of minority is an important call for every individual and for society as a whole. The state is responsible to create equal opportunity for everyone, regardless of whether they belong to the majority or the minority. Another important aspect to be considered is that minority protection requires active political steps in public programs like education, professional training, special measures to protect individuals, property and institution of threatened minorities. In a free democracy like India, minorities never feel oppressed. To sum up, it can be said that the obligation of the Constitution to protect the human rights of minorities from Operation Warden's discrimination matters a lot. Though the record of India in the change since independence does not appear to be satisfactory, we still wish that democratic ideas in the preamble of the Indian Constitution will someday be a reality for human rights of minorities as well. Today's cultural diversity is declared as enrichment of societies. New instruments provide the obligation of state to create adequate condition for expressing, preserving, and promoting the human rights of minorities' identity, as well as to provide for an atmosphere of tolerance and dialogue. Human rights of minorities are a form of rights enjoyed by a citizen as enshrined in the law. Let me conclude by saying you something. Mahatma Gandhi once rightly said that civilized nature of a country should not be judged by the way it treats human rights of minorities. Thanks to the chair and other dignitaries for giving us this opportunity. Thank you.
Thank you so much for highlighting the important question related to the minorities, both of you, Sarah Wilson and Anjana Sainuddin. Now over to you, Professor Anjana Mishra, because Professor Dr. Ajay Kumar is going to give the concluding remarks. Professor Dr. Ajay Kumar.
Yes, madam.
For giving the concluding remarks for
Good
this
morning.
session, first technical session.
Good morning to all of you. There are 6 papers which was presented in the first technical session. One by Neha Saxena on law relating to surrogacy. Second one is on Dr. Vinita Das, impact of patriarchy and the women's empowerment. Third one is on by the Sahina Ahluwalia on effects of COVID-19 and its gender impacts. Fourth one on Pallavi Devi submitted on law and adultery. Fifth, Dr. Jyoti on Bihar ke Pravasi Mahilaon ki Shaikshanik Adhikaron ka Shoshan. Sixth one is by Sarah Wilson and Anjana Sainuddin about the minority rights. Now, looking into the aspect of all those 6 presenters, one isn't a common observation is there, which I wanted to say to definitely to the organizer and those who are presenting it. Let's look at to the seminar theme which is there. Seminar theme is the human rights, legal and social perspective during second wave of COVID. Now, any paper which is going to be presented, I find that in a 6th paper only Sahina Ahluwalia has able to correlate the second wave of COVID-19. But all those are on 5 papers are independent papers. But I'm not saying that the papers are not good. They have presented well, but it has to be keep in mind while presenting in a seminar that whatever the seminar themes are there, you have to have correlate with that. It can't be presented independently. But I'm just correlating into that in respect. Now look at the human rights aspect which is there. As per the Constitution itself, the equality, liberty, and freedom of rights is considered to be this 3 aspects where when any issues relating to question of human rights are there, will have to be observed through these 3 golden triangle which was decided by the Supreme Court. That looking into the facts of the equality, liberty, and freedom, and the state is also under the obligation to protect it. So for the concern of the paper relating to the Neha Saxena is there, in relation to the law of surrogacies are there. This bill is still under, the surrogacy law is still under the, in a bill itself, a draft bill is there. So there are many discussions are going on, but as the convention which took place in relation to the to take care of the commercialization of the surrogacy itself, the government or the Supreme Court, under the Supreme Court has taken action on that. And the development of this surrogacy is concern of law and technology. So keeping in the view to the technology development itself, it is essentially to see that any law which are going to made in the form of a surrogacy does not amount to or violates the basic principles of the human rights of the fundamental rights which are enshrined in the Constitution. And that is why commercialization of the surrogacy is being restricted. Now, Vinita Das, Dr. Vinita Das has submitted the paper in reference to the impact of patriarchy. In a Northeast state, when we look at the Northeast state, in general, we can say it that there is for the purpose of women empowerment itself, the constitution has started upgrading it and has started giving the rights to the woman and for the purpose of women empowerment. So for the concern of the constitution, it does not differ the man and woman separately, because look at to the right of Article 14 itself, it does not define that what is man and what is woman. And the Supreme Court has already said that wherever it is man, it is considered to be woman itself. So there is no law which discriminates the woman itself. Though it's only question relating to the social awareness are there, because law is already protecting the man and woman equally. It is only the social awareness, or the society has to take care of that how they are going to give or extend the right, similar right to the woman itself. So naturally, the women's empowerment or question in relation to the women's is to be measured, has to be taken by the society itself. Saina has already pointed out rightly about the discriminatory rights which are there, as well as the whole paper which she has submitted on that. And she has already said about that there is a lack of awareness and a lack of educations are there. So it's true, it can be accepted, because we have seen it that the ratio, educational ratio is between the man and woman is different. As the last presenter has given as a non-doctrinal research which she has submitted about the Dr. Jyoti, about the Bihar Parvasi Mahilaon ke Shaikshanik Adhikar. We find it that there is a discrimination itself, but the state is also trying, and the law does not state about that. So it is altogether comes to that it is only the awareness which is essentially required among us also or in the society, which will take care of the man or woman equally itself. Now, next paper, Pallavi Devi submitted of the law on adultery and has given the journey of from one case of 1954 to till date. Now, so law is always changing. As the society changes, law changes. So definitions or interpretation gets changed. What is there in 1954 may not be true in the sense of in today itself. So while making an interpretation of the penal code itself, the Supreme Court has also examined the current position of that. And that is why we find that there is a changes and the development. So even adultery, where he said about that the when women cannot be considered as an abator, that depends upon the facts and depends upon the development of the society. So we may find in the future also that there may be different changes will be there when the society gets changed or society gets advanced. So you may have an impact on the law of adultery also. Jyoti has submitted, but so far my question with or came in my mind about that she has selected only those areas from where the migrated persons are coming. But in Delhi also there are many migrated areas where the peoples are settled from the different places itself. And if you look at to the educational institution of Delhi, you will find that there is more than 40% of the students are coming, women's students are coming from the different state. So that has to be taken into the consideration, showing it that there are certain women are there, societies are there, who is also promoting their women child to go to outside the state for the higher education itself. So if you look at to that data itself and you combine the data, you will find the results is different. Sarah Wilson and the Anjana Sahibdeen has submitted about the minorities, right? It is already said while making a constitution itself, it was already had in the Constitutional Assembly debate itself while talking about the minorities, right? It was already ensured under the constitution that the minorities' rights are remain protected itself. And so far the concern of the human rights are there, wherever the class of people will be there, or a class of employment will be there. So the basic rights which is there under the constitution, which is protected under the human rights, cannot be alienated even by the state itself. And that is a golden triangle when we say about that equality, liberty, and freedom. So thank you, madam, for giving me opportunity for interacting with all of you and sharing the session. I'm remain grateful to you, madam. Thank you very much.
Thank you so much, sir, for chairing this technical session of the second day international conference session on human rights, legal and social perspective during the second wave of COVID. I hope all the participants must be benefited by the suggestions given by you. They will take definitely cognizance of what you have said for their paper and the suggestions, valuable suggestion which you have given it to them. I hope they will consider the same. Thank you so much, sir. Once again. Thank you, sir. Now over to you, Professor Ranjana Mishra, ma'am.
Yes, thank you, sir, so much for giving all these suggestions. And we are really honored to have you for this session. And whatever suggestions you gave, even some of them were coming into my mind. And now this session is open for question answer. Like if anybody has questions to ask, they can ask questions. And for this session. So once again, thank you very much. And if you have some important work, then you can go because we still have 5 minutes with us. And if you can bear with us.
I will be there up to 5 minutes, madam. No problem. I'll be there
Any
for 5
questions?
minutes.
Any questions?
If there is any question, please. Actually, I have a few questions. Like, can I ask them few questions?
Yes, madam. Yes.
Okay. So my first question is to Binita Das. And she, at the outset, I want to congratulate to her that participation of women in legislature, of Assam and all those is minuscule. But she should have, because when Vinita, you are doing research, you should have given reference of Pushpalata Das, who became the first cabinet minister from Northeast, and then Swarnlata Mohanto also. So, like one should have a holistic approach towards research. So not only just the negative, because we are women, naturally we have been neglected. But now in the past also, there were few examples, but large number of women were not taken into consideration. So we should have highlighted that. My second question is to Sahina, and that is at the outset, I really want to congratulate Sahina, but like you focused on, are you there, Sahina? Shahina, like you presented a paper on healthcare services during COVID-19, but here I have just one doubt in my mind. It was a wonderful paper, but as Ajay sir said, like quite a few aspects you have not taken. First of all, like already he said about COVID-19, and what I wanted to just highlight that there were like quite a few measures were taken for healthcare. So you have to do the comparative study and then come over to the conclusion. So instead of just being biased and just highlighting, no doubt there was bad healthcare, like there was no healthcare that was provided to large number of women and they were deprived of that. But it's not that. Some of them, they did get their rights, like all those who were pregnant women, and they were given importance. So you should have cited it with lots of case studies and, on the basis of questionnaire. My third question, like that was the point that I have in my mind, is for Jyoti. And Jyoti, like again, I want to congratulate you, but as sir said that quite a few migrants are there. But here I just wanted to ask you one thing. क्या आपको लगता है कि अगर वो सारी लेडीज पढ़ी होती तो उनको रेस्पेक्ट मिलता, बिकॉज आपका एक फाइंडिंग है। तो उन पढ़े लिखे लेडीज से भी, माइग्रेंट लेडीज या अप्रवासी विमेन का भी आपको डेटा इसमें देना चाहिए, तभी आपका पेपर फुल पेपर माना जाएगा, रिसर्च पेपर माना जाएगा। Then to Azna, sir had already highlighted, so I'm not again highlighting on those points, but like when you talked about Muslim, Christian, you know, there are so many minorities, like Buddhists are there, Jains are there, Zoroastrians are there. So when you are presenting a research paper, and then tribals are also there, SC, ST are there, you have to encompass, because minority does not mean just one or two community or three communities. And as Sir Ajay sir very rightly said, already in our constitution, we have taken care of that, but it depends on the social consciousness, how conscious we are. So it was no doubt a very, very fruitful technical session. And I'm once again immensely, profoundly grateful to Dr. Ajay Singh for coming, Professor and Dr. Professor Ajay Singh, the Dean of Law, for giving us, and to the human science teachers also, insight into laws. So once again, I thank you, sir, for chairing the session, and thank you, Priya, for handling the session so nicely and so professionally. Thank you.
Thank you so much, ma'am.
So we can now switch over to second session, and now the second technical session, we will start it just now, as we have large number of papers. So this session will be headed by Pallavi. Pallavi, are you there? Pallavi ma'am, are you there? Dr. Pallavi? Am I audible?
Yes, ma'am. Yes, ma'am. I'm there. Yes.
Okay. So now you have to, and you have got the program schedule. So first you can make an announcement, like how many minutes you are giving to the readers. Because what happens, the researchers, they are unaware of it. So divide the timing and tell them the time schedule that they have to confine to that. Okay. So that will be of a great help to you also. Thank you. And now I ask Priya to conduct the session. Priya, have you got the program?
Yes,
Okay.
yes, ma'am. Thank you so much, ma'am, for giving me this opportunity. So we are now moving to the second technical session. A very good morning to Dr. Prabha Ravi Shankar, ma'am, because ma'am, you are there still with us, and it's a blessing for us that you still try to guide us whenever it is necessary. Over to you, Pallavi, ma'am. So the very first speaker is Dr. Vivek Mishra. He's a management professional and he's visiting faculty law university. So Dr. Vivek Mishra, are you there? Please unmute yourself. Dr. Vivek Mishra.
Is he not there?
Dr. Vivek Mishra. We are not getting any response.
Ma'am, he is not in even attendees list. I am trying to contact him. So please proceed, ma'am.
Okay.
Should I carry on, ma'am?
Now, the second
Should I carry on?
Yes, please. You are welcome.
So the second speaker is Sana. I would like to take the names of all the speakers so that they can prepare themselves one after another. The first speaker is Sana Fatima with her quoter, Dr. Madhu Singh. The third speaker will be Raju Kumar, Chanakya National Law University. The fourth speaker is Mr. Gakul Shankar and Miss Mimi Darshana. The fifth speaker, Mr. Prakash Kumar. Sixth, Miss Fatima Nahana and Uttara Kem. So all the speakers, you can keep yourself ready with your papers and if you have PowerPoint presentation. So we move to the to our present speaker, Sana Fatima with Professor Dr. Madhu Singh.
Yes, ma'am. Am I audible?
Yeah.
Okay, I'll be presenting the paper on behalf of both of us. A very good morning to all my respected teachers and the panelists and everybody, the chairperson of the session, and a very sincere thank you for giving me the opportunity to present my paper. Before I start my paper, ma'am, I would like to give you a little information that my paper, the heading of my paper that was written in the list is wrong. I am presenting the paper on the topic legal empowerment through promotions of human rights among persons with learning disabilities, and it was written something else. So I messaged also last night, but I did not get a response. Please kindly correct it, ma'am. And I'll start my presentation now. My paper is about the children, those who are suffering from learning disabilities. There is a very vast section of children in our country and all over the world who are suffering from what is called a learning disability. In a very short, I would like to tell you all, there was a movie which was shown to all of us a few time back, and it was a Amir Khan movie that was named Tare Zameen Pe. And that was a movie based on a child that was dyslexic. Ishan, named Nishan, and that is the source, that is my area of interest, and that children of those type I am talking about, and my paper is about them, and my research is also about them. We are facing a great difficulty in the acceptance and the rights of these children, because these children are marginalized, because the parents and the teachers and the other stakeholders are not ready to accept that the child is a learning disabled or he has a problem, and they just rebuke him or they just torture him out of ignorance or lack of knowledge. And my paper, I have given the information what actually the world and our constitution and all our other governments have given the incentives for such children. So I'll start reading these incentives that have been given. There is one. There are several relevant human rights. There is one. Human Rights Act 1988 that became law. The rights of all those children and vulnerable adults in particular have also been bolstered by the added legal effect of the act. For instance, human rights are at the very core of personal central planning, which aims to give people with learning disabilities the right to be treated and live life with the same rights, choices, and opportunities as everybody else without facing any discrimination. So here are some of the relevant rights. There is article.
इसमें टेक्निकल इशू दिखा रहा है और उसमें अटेंडीज में एरर दिखा रहा है उनको प्रमोट करने में.
Meru, please mute yourself.
Can I continue?
Yes, yes.
Okay, ma'am. Article 2, the right to life. This right is universal and limitless, and people with severe and profound learning disabilities therefore have the right to life-saving medical treatment and to treatment that prolongs life. Then there is Article 3. Everybody has the right not to be tortured in an inhuman or degrading way. For people with learning disabilities, this right means that they are legally protected from both any kind of mental and physical abuse. They are protected from living in poor conditions in institutions with the right to be protected from any form of neglect. Then there is Article 14, the right to be discriminated against in the enjoyment of your own rights. This right This article has a particular relevance to those with learning disabilities. Along with certain other legislations, such as the Disability Discrimination Act, this right helps to ensure that people suffering from learning disabilities are not discriminated against because of their learning disability. There are some other human rights that are given to such children, like Article 5, right to liberty, Article 6, right to a fair trial, Article 7, right not to be punished for something which wasn't against the law, Article 8, right to respect for private and family life, home and correspondence, Article 9, 10, 12, Article 1, 2, 3 under Protocol 1. Then there are several human rights that we have in our India that our constitution has given for such children, those who are suffering from learning disabilities. There are quite a few rights, and it will take a long time. I will only give 2-3 rights that are really relevant for such children. Then there is the constitution ensures to the citizens, including the disabled, a right of justice, liberty of thought, expression, belief, faith and worship, equality of status and of opportunity, and for the promotion of fraternity. Then there is Article 15(1), enjoins on the government not to discriminate any citizen of India, including the disabled and the learning disabled people, on the ground of religion, caste, sex, place of birth, etc. There shall be equality of opportunity for all citizens, including the disabled, in matters relating to employment or appointment to any office under the state. Then there is Article 23, Article 24, Article 25. No disabled person can be compelled to pay any taxes for the promotion and maintenance of any particular religion or religious group. These were the rights as common that were given to all. Then there is the National Trust for Welfare of Persons with Autism, Cerebral Palsy, Mental Retardation, and Multiple Disabilities Act 1999. This has also given many rights to the people who are disabled and also who are learning disabled. Then there are the Persons with Disabilities, PWD Act 1995. The Persons with Disabilities Act 1995 had come into enforcement on 7th of February 1996. It is a significant step which ensures equal opportunities for the people with disabilities and their full participation in the nation building. What actually this right gives is that prevention and early detection of any sort of disability, education to them, employment, non-discrimination, research and manpower, development, affirmative action, social security, and grievance redressal. All these things are given to any person who is learning disabled through this act. Then, apart from these, there is provisions that are specific to learning disabled. I will read them out. There is some extra time that is given by the CBSE board to the people, to the children who are suffering from learning disabilities. Some extra time is given to the students with specific learning disabilities during examination in order to help them. That is 15 minutes extra per hour. The students with specific learning disabilities are exempted from studying second language and substituted with the work experience subject to make it easier to them. They are permitted to use calculators for mathematics calculation during examination. For the students who suffer from dyslexia, the question paper will be read out during examination. Students with learning disabilities are exempted from spelling errors made in the answer sheets. Students with specific learning disabilities are exempted from drawing any sorts of maps, figures, or charts in the written examination, and they are given supplementary questions to complement the marks. Students with dysgraphia are allowed to use writers during their written examination. Students suffering from specific learning disability studying in 10th standard are exempted from studying algebra and geometry and mathematics. Grace marks of 20% should be given to any student who is suffering from learning disabilities. Students with learning disabilities are exempted from writing answers in details. And for students suffering from learning disabilities from standard 1 to 10, along with the written test, the person also is entitled for an oral test. Hence, it can be seen that taking serious note of the hidden problem of learning disability, quite a few acts and provisions have been formed nationally and internationally to safeguard the human rights of people suffering from learning disabilities. Most of such children and adults have to face a lot of troubles in their daily life as they need special care and provisions to make them feel normal about themselves and the things around them. The government of India still needs to formulate a separate policy for such people, and they should implement it at their earliest as people are suffering due to the lack of ignorance and lack of acceptance. Thank you, ma'am.
So thank you, Professor Madhu Singh, for your paper, Children Suffering from Learning Disability.
Thank you, ma'am.
Where your paper have focused not only on the laws and also the content, but you brought out a very important problem that children suffering from disabilities suffer in several levels: attitudinal, physical, and accessing to health and education. So for a sustainable development and for an inclusive development, we should, it's not only, it should not only be the duty of the state, but it should also be the moral duty to bring an overall development.
Yes,
So
ma'am.
in that process, we will not only unlock their potentialities, but we will get the contribution from those children who are suffering learning disabilities, because they have so much to contribute. So thank you, Professor Madhu, for your wonderful paper. We will now move to the second speaker, Raju Kumar. We will move to the next speaker, Raju Kumar from Saneka National Law University. Is he not present, ma'am?
Ma'am, Dr. Vivek Mishra, he has sent me a message that he will be not available today due to unavoidable reasons. So tomorrow he is going to present the paper. So he has asked me for kindly accepting this. Due to unavoidable circumstances, he's not available here.
You are muted, ma'am.
Yeah, so we can, Pallavi, you can announce the third name. Thank you.
So the next speaker is Mr. Gakul Shankar and Miss Mimi Darshana from Tamil Nadu National Law University. Yes. Are they not present? So, ma'am, from Gakul, there is a message that he cannot unmute himself. Can you address the problem?
Hello, the technical group, can you unmute him? Hello, Meru, are you there? Meru, Rajesh Chheda sir, are you there? Hello. Just
एक्चुअली मैंने उनको किया है, पैनलिस्ट में मैंने डाला.
Okay, so have you already done that, Meru?
Yes.
Okay, so now he'll be joining.
Hello.
Yes, Gokul Shankar. Now we can listen to you. Now we can hear you.
Okay. Thank you, ma'am.
Okay.
Good afternoon, everyone. Myself, Gokul Shankar, and Mimi Darshana, students of the Tamil Nadu National Law University, are grateful for this opportunity to present our research work.
So you are not audible again.
You can hear me properly?
Gakul and Mimi Darshana, you are not audible. Please check your connections.
Okay, Mimi, ma'am, if the chair permits, could we proceed to the next paper presentation? Because he would be joining in a little later. He said there was some technical glitch. Prakash Kumar, are you there? Mr. Prakash Kumar, Chanakya Law University.
Yes, ma'am, I am here.
Could you please share your screen and start the presentation? Prakash Kumar, Chanakya Law University, and the title of the paper is Witch Hunting, a Blatant Violation of Women's Rights.
Yes, ma'am. Honorable Chairperson, Convener and Co-Convener, ma'am. A very heartiest good afternoon to all of you. My paper presentation topic today is Witch Hunting, a Blatant Violation of Women's Rights. Believe in a country which is socialist, sovereign, democratic, and the largest republic nation of the world. However, beauty of this country do not stop here. Along with such a marvelous nation, we live in a country where we treat land as our mother. Even we treat animals as our mother. It is a strength, wealth, and intelligence which is the most essentials of everybody's life. And we worship Goddess Durga, Goddess Lakshmi, as well as Goddess Saraswati, who are believed to be the goddess of these three basic attributes of human life. And more interestingly, these all are a women. We live in such a country where men and women are treated equally in every field, even in army and NDA as well. But on the other hand, it is very sad to say that in most of the cases, only it is women who is treated as a witch, Dayan, Tonahi, and many similar adjectives are given to them. How contradictory it is, ma'am, I cannot express in my words. Tears rolls down when it is seen that any woman is tortured in a belief that she is a witch. She has a black magic and can do harm to others. It gives me immense pleasure to express that it is women who has 7 times more toleration power than men. But it is of no use in such a place where she is named as a Dayan. Ma'am, witch hunting in present scenario becomes a serious crime, primarily in rural area. In this modern society, after these much developments, this superstition is terrible. In fact, literate person also in society have belief in this type of superstition and they are involved in it. Which means any woman who has alleged as witch by person or person in belief that such women has some devil power to harm anyone, or that she allegedly have such intention or having the belief that she has bad eyes or evil eyes, or could do black magic, or that she by mantras can harm people or society at large in any manner. Here question now arises that why witch prevail in female gender only? Is patriarchy is the reason for the same? Ma'am, in society, faith in witch is in women's section are more than male. Women herself believe that there is a witch in her or other women body or soul. In childhood, I myself heard lots of story of witches from my mother and grandmother, but never heard such a story from my father and grandfather. So women have more faith in witch, and men are compelled or they are trained by women sector of society only from their childhood by various ways like a story, fear, fiction, etc. to have trust in witch. So in direct way, patriarchy is not sole reasons for witch hunting, but indirectly it may be. Because due to patriarchy in society, literacy of women, development of women mindset, quality of life is very poor, mainly in rural area, which give result of this type of serious crime. Now, for moving further, the concept and practices of witch hunting is not a new development in India. Its traces can be found in primitive age, medieval age, in the modern period as well. The concept of witch hunting initially started in Europe in early 15th century, and now its practices can be seen all over the world. India is a country where women are worshipped, considering them as symbol of goddess. But it's very sad to say that on the other hand, they are killed, considering them as a witch. It is believed that for their own betterment, they misuse their devil power and kill the innocent member of the society. And also they are given various unacceptable, unethical names like Chudel, Diane, Tonahi, etc. in the blind faith of which has no any relevant logic. The innocent women are killed and also subjected to various type of offenses like rape, manhandling, assault, defamation, etc. Ma'am, according to National Crime Record Bureau, more than 2,500 people in India have been tortured and killed in these hunts between 2000 to 2016, most of them being women. However, people say that number is much higher because states don't list witchcraft as a motive of murder. Second, as researchers think that superstition works as catalyst. Why people believe in witch hunting is only one reason, that is superstition. It works as a catalyst. There are many reasons behind witch hunting, such as lack of education, lack of awareness. However, the protagonist is the superstition. It works as a catalyst which stimulates the practice of such social evil. It is a kind of belief which scientifically do not exist, but people are still believing in such existence. Being under the trap of superstition, people can go to any extent. An astonishing event took place in village Ganjam in Odisha on that time when a Dalit family was forcibly instructed to break their teeth. How inhuman activity this is, I cannot explain in my words, man. Also, they were fined a heavy cost of 50,000, which was a huge amount for a poor Dalit family. Man, during the outbreak of COVID-19, when whole world was facing the challenge to keep them alive, some of the superstitious activity was growing at a large scale. People went to the extent of worshipping coronavirus, naming as Corona Mai. When doctors were fighting against coronavirus, on the other hand, people were worshipping the COVID as Corona Mai under superstition. Examples came from many parts of the India, such as from Hajipur of Bihar, Varanasi, Kushinagar, Ranchi, West Bengal, and many more. The worshipper even forgot about mask and social distancing. This is the highest point of superstition, which can be eradicated only by way of awareness program. Here, some of the laws has also been framed for the eradication of witch hunting. However, these are not very efficient. Bihar is the first state who have implemented the Bihar Prevention of Witch Practices Act 1999. The act under Section 3, Section 4, Section 5, Section 6 provide penal provision and says as follows. Section 3 tells about the identification of witch as any person as witch and does any act towards such identification either by words, action, or manner shall be punished either by imprisonment for a term which may extend to 3 months or fine of ₹1,000 or with both. How this witch hunting is a violation of women's rights? This is the next question. As we know that to run any vehicle, at least 2 wheels are required. And even if only one become out of order, then it is impossible to move. Like same way to run the human life, men and women are 2 wheels. And in the absence of anyone, it is hard to even imagine the existence of human life. It is also said that without mutual cooperation, any operation cannot be successful. We should respect women not only because they are women, but we should respect women because they are human beings. It is clear that all human beings have human rights inherited to them regardless of race, sex, nationality, ethnicity, language, etc. As far as witch hunting is concerned, most women are subjected to extreme torture and severe kind of social boycotts. According to police data published by the Times of India newspaper, some 123 people were killed by mobs in Jharkhand between May 2016 and 2019 in the suspected use of black magic, and all of them are most of they are women. It is not new only in India. However, it prevails in Hungary, Denmark, and England. There are roughly 90% of known witches are women. Similarly, women in Nepal face the possibility of being branded as a witch and subsequently tortured. Witch hunting is the least talked form of violence against women and vulnerable signal. Women or widows mostly fall prey to such superstition practices. It leads to loss of many lives every single year. According to recent study, there are 2018 reported deaths in India due to witch hunting from 2001 to 2012. These could be in all likelihood underreported estimates. Women are subjected to as much as possible torture, and it can be seen in daily life too. Black events like making a woman naked, compelling them to eat human extracts, cutting their hairs in public, painting their face black, and many more which cannot be explained in my words. These are enough to show that witch hunting is a blatant violation of women's rights. The most hurting point is that we are killing and torturing the alleged women on such a type of allegation which does not exist scientifically, and we are responsible for this type of practices, which is really a black spot on our society. At concluding remarks, I would like to say that witch hunting is such a black spot which should be washed off in any way, and it should be stopped without any delay. However, IPC do not have any specific provision related to this. It is only dealt under hurt or murder. As per my opinion is concerned, a separate section should be inserted in IPC dealing such issues so that such practices can be cured effectively. The society do not have any right to violate the human rights of any person, and accusing a woman to be a witch is a severe violation of women's rights as well as human rights. We should understand the seriousness of witchcraft, as it is a hindrance in the development of our country. Nothing can be more heinous than torturing a woman to such an extent of compelling her to eat human extract, drinking urine, and even ostracism too. However, it is the duty of the state also to make such strict laws which can eradicate the practices of witch hunting. The Union Government of India should make a uniform law to tackle the problem and make the punishment so harsh that it can be taken a deterrent theory of punishment. But the researcher is sorry to say that it will not enough to only make a strict laws, but its implementation should also be up to the mark. Government should also organize awareness program via advertisements, movies, poems, and using any such methods that can touch the inner soul of human being, irrespective of male or female. Then only it will be possible to minimize the said problems. Thank you, ma'am.
Thank you, Prakash. Can you please connect to Raju Kumar, because I hope he has not yet presented the paper. So please gather the information and send it to us as soon as possible.
Okay, ma'am.
Over to you, ma'am. Over to you, ma'am.
Yes, we proceed ahead. I think he had joined in. Shankar had joined in, but again, he's not visible. We could move ahead. Fatima Nahania, are you there? Fatima?
She is there, ma'am.
Sana Fatima. Sana Fatima?
Yes, ma'am.
Yeah, could you please present your paper?
Ma'am, I have just presented my paper with my guide, Dr. Madhu Singh.
But no, the other candidate, Fatima, she's Fatima Nahana.
Yes, ma'am. She is somebody else. I am Sana Fatima, and I presented the paper on behalf of both of us.
Yes, thank you. Thank you.
Thank you, ma'am.
Amongst the participants, Fatima Nahana, could you please kindly unmute yourself? Yes.
She is there, ma'am. I got a message right now in the chat box. She said that she is there. Fatima Nahana.
Yeah. Fatima, please kindly present.
Hello, ma'am. Am I audible?
Yes, Fatima Nahana and Uttara KM, Al-Zahar Law College. They're presenting on, title of the paper is Human Rights of Migrant Workers During the Pandemic. Fatima, please start.
Good afternoon to all.
Start with your paper.
Okay. Good afternoon to all the panelists and attendees of this session. Myself, Fatima Nahana, and my co-author, Uttara KM, is here to present our research paper on human rights of migrant workers during the pandemic. The lockdown has been a long haul in the battle against coronavirus, but the migrants are suffering from the worst, hitting the hardest. Human rights and dignity of migrant workers is a matter of serious concern in the present scenario. The recent lockdown situation created by pandemic has put them in a more risky condition. This led them decide to leave the state of work and return to the state of origin. This journey with no money, no food, and mostly on food led to unusual humanitarian crisis. This review summarizes that the fundamental and socio-economic rights granted upon labor laws and human rights were breached extensively during the lockdown. The World Health Organization defines health as a state of complete physical, mental, and social well-being, and not merely the absence of disease or infirmity. Migrant population, being a non-native population, is vulnerable and is exposed to many health problems. Poor working condition, poor living condition, lack of job security, meager salary, inability to fulfill their own needs. Exploitation by contractors are the other factors which also contribute to the stress, which in turn leads to loss of immunity and health. Now, let us look upon to the analysis of challenges faced by migrant workers during pandemic. Migrant workers are more prone to various social, psychological, and emotional traumas in such a situation of pandemic, emanating from fear of neglect by the local community and concerns about well-being and safety of their families waiting in their native places. During the outbreak of communicable disease such as COVID-19 and the restrictions imposed on routine activities as part of social distancing norms to prevent the spread of the disease, scores of migrant workers tend to move back to their native places. Many of them are, however, stuck at borders, including state, district, and at national border areas. These are the most marginalized sections of the society who are dependent on daily wages for their living and in times of such distress need sympathy and understanding of the society. Immediate concerns faced by such migrant workers relate to food, shelter, healthcare, fear of getting infected or spreading the infection, loss of wages, concern about the family, leads more anxiety and fear of them. All this calls for strong social protection. Now, let us look to international human rights and labor protection law. International human rights law guarantees everyone the right to the highest attainable standard of health and obligates governments to take steps to prevent threats to public health and to provide medical care to those who need it. Human rights laws also recognizes that in the context of serious public health threats and public emergencies threatening the life of the nation, restrictions on some rights can be justified when they have a legal basis are strictly necessary. Based on scientific evidence and neither arbitrary nor discriminatory. In application of limited duration, respectful of human dignity, subject to review, and proportionate to achieve the objective. The fundamental rights accentuate individual security and autonomy, and their base reposes on the pillars of human dignity, equity, equal rights, equal consent, and equal reverence. These rights gain prominence when Article 1 of the 1948 UDHR Declaration affirms all human beings are born free and equal in dignity and rights. The ILO Constitution declares that all human beings, irrespective of race, creed, or sex, have right to pursue both their material salutary and their spiritual development in conditions of liberation and dignity. It has been observed that migrants and refugees exude special interest in liberty and personal integrity rights, procedural rights, family rights, employment rights, political rights, and cultural rights. But the majority of the migrant workers, particularly those doing low-wage jobs in developed and underdeveloped countries, enjoy very few of the rights outlined in the International Convention. With the establishment of the International Labour Organization in 1990, the efforts to standardize the workers' and migrant rights gain momentum. To date, ILO has developed and passed many conventions, of which 8 are core conventions that talk about the fundamental rights of workers. In 1990, the General Assembly of the United Nations adopted the International Convention on the protection of the rights of all migrant workers and members of their families. However, this protective provision of the convention ability to ameliorate the human of anomalous migrants is significant. Apart from law, social cognitions of migrant workers are vital crucial to the human rights issues that circumvent them. Now, the rest of the presentation will be by co-author Uttara.
Fatima, Uttara, has she joined in at the attendees? Uttara came. Uttara, please continue.
Ma'am, audible?
Yes, Uttara, you're audible. Please continue.
Okay. Now let us move to the
Uttara, there is some network concern. Please. Uttara, your voice isn't audible.
There is some technical issue, ma'am.
Yes, Fatima, if you're there, please kindly continue, and because it's difficult. Uttara, could you please continue, or we move on to the next?
Okay, ma'am.
We asked to Fatima to give the conclusions and suggestions. Fatima.
Pallavi ma'am, in the chat, Gokul Shankar has said that he is there. If you go through the chat box, he's there.
Yeah, he is on the main screen, ma'am. Gokul Shankar is available.
Raju Kumar is not well. I got the message right now, so most probably he will join later.
Uttara has finished, ma'am, her presentation.
No, not yet.
No, ma'am, but there's a technical glitch, so
technical problem.
So should we move to the next speaker, ma'am?
Yes, ma'am. We may continue with Gokul Shankar. Gokul Shankar, could you please kindly unmute and start with your paper? Gokul Shankar and Ms. Mimi Darshana, they are speaking on human rights of migrant workers during the pandemic. Gokul Shankar, kindly unmute yourself and start.
Yes, hello. Hello, am I audible?
Yes, you are audible.
Okay. Firstly, I would like to state that there was a mistake regarding our paper's topic. Our paper topic is
ending, ma'am.
Is the governmental control of population and infringement of reproductive rights of women in India.
Yes, ma'am.
Gokul Shankar, we are sending you a registration link. Kindly update the details so we can change it. Thank you for bringing it to our notice. We will do the needful. You may continue with your paper now.
Okay, thank you. Good afternoon, everyone. Myself, Gokul Shankar, and Mimi Darshana, students of the Tamil Nadu National Law University. We are grateful for this opportunity to present to the distinguished delegates of our research work on the governmental control of population and infringement of reproductive rights of women in India. Our paper dwells upon the extent of the government's control of an individual and general public and human rights at large. Our paper has clearly laid out the flaw in the two-child policy and has voted against it, both because of the non-necessary for it and because of its violation of human rights and women's reproductive rights. Now, what is human rights actually? Human rights are equality for all without any discrimination, regardless of nationality, sex, gender identity, disability, ethnic origin, religion, and reproductive rights. Clearly, human rights are the most fundamental and the most inalienable rights in nature, which none can deny to anyone. A pandemic or not, human rights are inalienable and are fundamental to every individual. Reproductive rights is also a part of that inalienable human rights. On the broad view, reproductive rights of women are one relating to the most sacred and dignified standard of morale which none can deny. It is a right in which a woman can determine on the number of children she wants to have. It is a right in which a woman decides whether or not she wants to have sexual intercourse. It is a right in which a woman decides whether she wants to become a mother or not. The International Convention on Population Development, which India signed almost 5 decades ago, is unfortunately not working as effectively in the country as of now. Even as we speak, many people are denied government jobs. People are denied government jobs and the benefits of public distribution system just because they have 1 or 2 children more than the law specifies them to have. This is kind of denying the lives of all the children that could have born, and our paper states out the result of this two-child policy while comparing it with China's one-child policy, and it has also stated the need for an alternative to the two-child policy. The reason that our work have presumed that the result of India's two-child policy will be disastrous among the general public, both in the aspects of violation against human rights and against the dignity of women, is that our paper has analyzed the results of China's one-child policy and moreover the replacement level of fertility rate. Clearly, the fertility rate in most of the parts of India, at least in the states where the two-child policy has been implemented, are very near to the replacement level of fertility or even less. This indicates that the practical applicability of the two-child policy is completely unnecessary. Now, India's total fertility rate are declining already from around the year 2000 and are very near or even less than the replacement level of fertility rate. This draws us to the conclusion that India will not need a two-child policy even in the immediate future. And thus, the implementation of the two-child policy from the government is questionable. Let's take another perspective, being that the two-child policy is against the ICPD and many other international treaties. Furthermore, it also violates the fundamental and inalienable human rights, denying that a couple cannot have more than 2 children and denies women of their freedom to have their own number of children and their respect. Now, with regard to the policy itself, our paper has analyzed the many discriminating features it demonstrates. The policy allows people who have 2 or less than 2 children to get all the benefits of the government, such as increased salary, reservations in political stances, promotions in jobs, free education for children till graduation, etc., etc. These incentives are only given to those people who have 2 or less than 2 children, and not the others. And furthermore, this policy will be disincentive to people who have more than 2 children in the way that they will be deprived of their political positions in the local political bodies. They cannot stand in a local political stance such as the Gram Panchayat, and the government officials may lose their jobs and will be deprived of the benefits of the public distribution systems. Now it is very curious to know that the law itself is discriminating people on the basis of number of children. A question arises now whether it is the children's fault for getting their parents jobs. The answer is, well, obviously no. And as a result, this leads to the result of mass sterilization, both improper and proper, and forced abortions. Now, this is a serious situation at hand, being that the law itself is coercive and discriminative. What can the general public possibly do? Besides all this, there's another aspect, the government interfering in the private or the individual rights of people. And this is sort of the government is directly interfering in the personal and intimate matters of people, and thus destroying the separation of powers between the people and the government. In conclusion, our paper suggests the government for an alternative to this discriminating two-child policy, which hopefully will not include the negative aspects of the present policy. Moreover, the government, while drafting a better policy, should keep in mind the aspects of dignity and the reproductive rights of women and the general public at large as the most fundamental and inalienable human rights. Thank you.
Thank you, Gokul, for your paper.
Thank you, Gokul.
So, ma'am, who will be the next presenter?
We finished with only Uttara was not able to give the closing suggestions for a paper. I think we can proceed, and I'd request Dr. Pallavi, the PG Department of Law, Guwahati University, Assam, to please kindly give the concluding remarks for the session. Dr. Pallavi.
Yes, ma'am. Okay, so we have a very...
Can I interrupt here? Because can I give a short introduction of Pallavi first? And my apology, because Pallavi, we could not, it was solely my mistake, because I could not forward your CV to anyone because I'm totally bereaved. So please bear with me, and I want to introduce you. It's really a pleasure to have you over here. And Pallavi is, assistant professor from Guwahati University, from the law college, and she is having to her credit too many papers, and she has presented papers at national and international level, and she is very, very passionate about the research, and she has been, regular contributors to national, this type of research papers at national and at international levels that I said again. And she knows, like she's authority on law, and she has been guiding too, because as she has done her PhD from Northeast University, so she has been guiding too many research scholars. So once again, I welcome you, Pallavi. Now you can give, the review of the session. Thank you.
Thank you, ma'am, for such a generous introduction. Ma'am, like Sana have said, somebody have asked me here, Uttara came have asked us, all the panelists, to let her continue her paper.
So she can continue if we have time.
Yes, ma'am. It's like we still have 20 minutes in our hand. So please continue. Uttara came.
audible?
Yes, yes, you are audible. Please continue.
Now, we move to the rest of microservices in India. So, India has a numerous law and constitutional provisions related to the labor and migrant rights. So, the Constitution of India, from Article 40 to 60, 90 clause 1C, and 23 to 24, 38 and 41 to 43A directly concern labor rights. So, the Article 40 states everyone should be equal before the law, and Article 15 especially is say that the state should not discriminate against a citizen, and Article 60 a right of employment other. In the Article 90 clause 1 specific right association, Article 23 prohibit all the traffics and forced labor, while Article 24 prohibits child labor under the 14 years old in a factory. Mine or any other hazardous employment. Article 38 clause 1 says that in general the state should strive to promote the welfare of the people with a social order in which justice, social, economic, political, all the institution of national life. In Article 38 clause 2, it goes on the state should not minimize the inequality in income and based on all other status. And Article 39 clause D, the Constitution of India proclaims the equal pay for equal work, both men and women. As directive principle of state policy, equal pay for equal work for both men and women means equal pay for equal work for everyone and between the sexes. And Article 41 creates a right to work with the National Employment Guarantee Act 2005 attempt to put in a practice. Article 42 requires the state to make provision for securing just and women can work for the review. And Article 43, workers have the right to living wages of their work, ensuring standard leave, life, and this article to the to state to secure the provision of management undertaking. So, understanding of migrant workers, and second problem, varied needs and family. There is no generalization and help them to acknowledge them in unusual situations of uncertainty and the situations in transient to not going to last long. I concluding. The humanitarian crisis was the worst. The migrant is not in a position to take any health precautions, including much recommended of the social distance. In this motive, we are enforcing to start including the migrant in our mainstream society rather than maintaining the status and undertaking is happening to them and can help build a effective protection system. It is necessary to maintain important aspect of labor standards and labor rights and aim of achieving a system where there are no barriers on the smooth process of rule of law. Thank you.
Ma'am Uttara has concluded her paper.
So,
Pallavi ma'am.
Yes, ma'am. So taking regards and taking care of all the presenters, professors, students, and research scholars, I have not many things to comment, but Dr. Madhu Singh and Sana Fatima have presented a paper. Since I don't have the leaflet, I could briefly say that their paper was children suffering from learning disability. So yes, the paper can also talk about, can also bring about or emphasize on sustainable development also, because children, those who have learning difficulties, they also have much more to contribute. And we can also bring off concepts like ethical citizenship, because if we look, we need to bring more substantial element to the word state, because the state is more powerful, and we can also incorporate the ideas of moral duties, and also how it can reach to how we can create more resources and opportunities, and how there can be more equitable access to all the public and social goods, because that is the constitutional mandate, that there must be justice and equity to all of the people. And here, those children suffering from learning disability should also not be excluded. Moving to the next paper, Prakash Kumar, who was a student whose paper was on witch hunting, a blatant violation of women's rights, where he focused on a particular word, patriarchy. I would like to bring into a narrative that we, men and women, they are two halves. Like, so we as a women folk, we don't hate patriarchy. It is only the chauvinism that we dislike, or who needs as control, whether we need the state help. So also that lack of education and health services has also contributed a lot to the practice of hunting. And since the practice of witch hunting is only a superstition, so awareness is what how awareness can be carried to the grassroots level is also what you can like brings many kind of narratives, how women themselves can take decision, the decision taking power, or the reason, the power of reason. So moving to the next speaker, Fatima, Nahana, and Uttara, human rights of migrant workers during the pandemic. So I don't have much knowledge, but we have seen in during COVID-19 that the bureaucratic, the executive, the three organs of the government, the executive, that is the bureaucracy, they have taken extra care to be cruel. They have given chemical bathing, and they have treated migrant worker just like a commodity. So how has the executive not used the already existing law? We have many progressive laws, and this lockdown has also, COVID-19 has also exposed how our laws are not sufficient. We have sufficient laws, but also we do not have sufficient laws. One, the executive is not taking proper care to bring their element of duty, and on the other hand, there were certain loopholes in the law as to we have not followed the international instrument as to the concept of human rights, because it is always the fundamental right that gains the importance, not the human right. The next speaker, moving to the next speaker, Gokul Shankar and MS Mimi Darshana, government control of population and infringement of reproductive rights in India. You can also bring out the element of consent, privacy. It's none of the state's business to infringe upon those elements, because these are rights, these are the rights which are not a gift from the state, but these are some non-negotiable right that we have. So this is all what I have to say So over to you, ma'am.
Thank you, Dr. Pallavi, for diligently delivering the concluding remarks. We concluded for all the papers in this session, that was technical session 4. We break for lunch now. We meet again at 2 p.m. I'd request all the attendees to join in at 1:50 so we could avoid the technical glitch, if any. Sanjana ma'am, do we wind up for the technical session 4? Ma'am, you're required to unmute yourself.
Aren't we having question answer session?
Ma'am, we could continue if there are questions, because we've sent in the chat box in the previous day also, but we've no questions.
No, and if we have no question, then of course we can wind
Yes.
up.
So, again, a reminder or
I have certain questions and suggestions.
Please do.
Some of the paper readers.
Yes.
First, at the outset, I want to congratulate all the paper readers because all of them presented wonderful papers, and I know like it's so difficult to write papers. So please accept, my congratulations. But my first question is to Sana Fatima, and she read a paper on learning disability, and that was a wonderful topic because that area is like a very, very serious area where human rights have been violated. So I once again congratulate you, Sana, but there are few questions. I'm sure you must have incorporated it in your full length question, but in presentation it did not come. So my two questions are that learning disability, like whatever you presented, are they based on any case studies? And my second question is, how during COVID-19, because the paper is related to COVID-19, so they how in the schools they were evaluated. So did you contact those schools of physically disabled? Because when you are presenting a paper, then these points should be incorporated in your paper.
Yes, ma'am. Thank you for your question, and thank you for actually listening to so minutely my paper. Ma'am, actually, my research is based on this learning disability only that I am doing right now. And I am continuously visiting places, special schools, counselors, psychiatrists, psychologists, and I'm meeting with them. And yes, the case study you talked about, ma'am, I'm going through a lot of case studies these days. And when I was writing this paper also, I did not mention any special case study, but yes, I have gone through a lot of case studies for the paper as well as my research. And ma'am, during COVID-19, this evaluation, I'm talking to counselors, they told that even the normal children are really, really anxious, stressed, depressed due to this lockdown and not going to school, being confined in the four walls of the house and not being able to socialize, not able to meet people. And the children who are having learning disabilities, they definitely are a little bit more marginalized than the normal. It is really, really difficult to deal with these children. And today also I met a counselor at a school, and she was telling that those children who are having dyslexia or dysgraphia or ADHD, the problem gets really I can say it is more during this COVID time, because they don't have the direct contact with the counselor, and the parents don't know how to deal with such children. And in COVID-19 also, the children who are having online classes, normal children, ma'am, they face a lot of issues, but the children who are not very normal, you can understand that how much issue they could have faced.
Yeah, I just wanted whether you have incorporated, how they were evaluated when they got the promotion, because generally all children got, and on what basis. So just see that, I'm sure you must have, but this was the thing, if you will incorporate or you substantiate your paper with this type of facts, it will enrich your paper.
I'll definitely next time when I will meet the counselors at the school, ma'am, I will definitely ask the question at what basis they get evaluated at school. Some of those, though, are not profound, ma'am. They are normally, and the one in the special schools, I don't know the right procedure, what exams they are having.
That's the thing I felt. So your paper was
Thank you so much, ma'am. Thank you so much. I really appreciate that you have brought to my point, and I'll definitely see to.
Thank you. My second question is to, can I go ahead? My second question is to Prakash Kumar. Are you there, Prakash?
Yes, ma'am.
Okay. And this was wonderful because which, like burning and all those things, these practices are not only in India, but in abroad also. And I think you covered those things. But my question here is, like, I'm sure because of paucity of time, you did not highlight that, but that is there that did you highlight on the number of witch burning during that time? Because I had gone through 2-3 papers, and in the newspapers also it was written that the numbers had decreased during pandemic because people were more scared of COVID. So they were not in all these evil practices. So please see to it that if this COVID had it was a bane to the society. At the same time, it was boon in disguise to the society. Because in this area particular, there are articles, by Suresh Kumar in Jharkhand, because as you have done your paper on Bihar. So please incorporate these points. I am not remembering other articles that I had read, but these are the few points that if you include in your paper, that will become very good.
Okay. Yes, ma'am. Yes, ma'am.
Thank you so much. And am I boring everyone by asking questions or?
Not at all, ma'am. Please continue.
Okay.
No, ma'am.
Okay. So my third question is to Fatima Nahana. Fatima, are you there? Fatima, are you there? Fatima Nahana. Okay, because okay, if she's not there, it does not matter. But there were few points which were missing in her paper, and if her colleagues and like fellow friends are listening, please ask her to just.
Yeah, ma'am. She's there. She's there.
She's there. Okay. So what I wanted to tell her that it was a wonderful, like since yesterday, we had been hearing about migrant workers, what all problems they faced. And naturally, they faced innumerable problems. But she should have, in her paper, like she did not must be there. I'm not saying like she must not be, but there are quite a few states they neglected migrant laborers. Like, for example, Delhi, Bombay, and so many. They did not take proper, when they came also, they were put, they were confined to certain areas. They were not allowed to go. But there are certain states like UP and like, I'm saying because, not because I'm staying here, but government really took good care of them. How like they were kept, how they were sent, how transportation was arranged. So one should have not only just the negative aspect of it, one should always encompass, because research does not mean only negative points, but it also includes positive. Then only we will have a holistic approach. So thank you very much. Now we can go for lunch break. And thank you so much, Pallavi, for presiding over the session.
Thank you all. Thank you, Dr. Pallavi, for joining us. Yes. It is indeed a pleasure, and hope we see you soon when you come back to our college You'll be more than welcome to see you in our college campus.
Sure.
Thank you, Dr. Priyadarshini, and all the presenters. We resume back after lunch at 2 p.m. Thank you.